In view of the categorical direction of the Honorable Supreme Court, the prayers made in these writ petitions cannot be granted. Accordingly, both the writ petitions stand dismissed. Petitioners, however, would be at liberty to apply for the settlement of land under the present land policy of 2019, subject to fulfillment of all the preconditions necessary for such consideration.
May I please, Your Lordship? May I please, Lordship, this letter may come up for orders on Monday.
Orders?
Orders, as because Lordship, the case relates to requisition compensation. I am for the state. And I have been, I got the instruction that the amount has already come. So being the disbursing authority, Lordship, it can be disbursed to the petition.
Okay.
As because the case is pending that. On Monday.
May please, Your Lordship. This is an unlisted matter. Matter will be listed tomorrow, very urgent. The
Motion.
motion.
Consent of the document item
65. One of you two. One of them. 60? Yes, what do you need?
Amount.
Oh no, what do you want?
I want adjournment to it. It will be after 2 weeks.
You are for the respondent.
Yes, sir, I am for the respondent,
Why do you want adjournment?
which I have some legal.
Okay. On a request made by Sri M. Ahmed, Learned Counsel for the respondent was 6/2/11. Matter is adjourned to be listed after 2 weeks. List on, we give a date.
Interim order is there.
Just list on. Today's. এখন এনেকে
But
করা
maybe the first week of April.
এখন তাতে এনেকে এখন এইটাতে এনেকে list on today's
Any day in the first week of April.
first week of April. We can have it on 27th of March.
I will not be there. First week of April.
Okay,
But I'm going
on
out.
first of April. 1/4. Interim order passed earlier to continue till the next date of listing.
Can it be on story?
Why so much of time do you
I-
want?
I'll be out.
There's an interim order.
But it is against me. I'll be out. Some treatment.
Against you or for you is not the concern. There is an interim order. There is needs expeditious consideration.
Since I am.
When do you want? On 6th of April. 6th.
Interim order.
We have said.
May it please the Lordship, I am paying for listing of one motion matter on 13th,
When?
13th Friday.
That's why I need to mention item number 37.
Yes.
Paying on behalf of GST. The last occasion I paid before this one, I to file my affidavit of position for 1 week.
Yes.
The vetting has not been cleared from the department. So my department wishes to 1 week time to file my counter affidavit. The affidavit is-
37.
Yes, Lord, sir.
Dr. B. N. Goway, Learned Training Council, CGST, has renewed his prayer for grant of further time to file the affidavit in opposition. Para? Matter is accordingly adjourned by 2 weeks to enable filing of such affidavit in opposition. List on. We'll have it on 27th of March. 27th March. You get more than 2 weeks. Okay.
Lordship, interim is there. Lordship.
Interim order passed earlier to continue till the next date of listing.
Highly appreciated.
May it please your Lordship. Lordship, I beg to mention for listing and I for still vacating on Friday, Lordship. Obliged.
When did you file? Has the IA been registered?
Lordship, register, Lordship.
Okay.
10.
Friday we can have.
Friday, Lordship.
Yes.
Obliged.
May I please, Your Lordship. Lord, I beg to mention for listing of a motion matter as unlisted matter today, my lord. This
Why today?
eviction matter,
Eviction?
my lord. Today, my
Today, yes, we'll try eviction matters.
Right.
We'll try.
lord.
I have mentioned for Friday listing manner for execution.
Motion. Motion is,
Lordship, IA for order, Lordship.
IA has come up for consideration earlier. Or fresh IA?
Fresh IA.
Fresh IA?
Fresh IA.
What, IA is for what?
IA for strikeout of one of the petition.
We'll have it Monday.
Monday.
Yes, your Lordship.
Lordship, with regard to item number 41 of the daily list, you have filed an additional affidavit yesterday, Your Lordship, the records of it.
May-
Lordship, beg to make a mention for listing of two items for motion on Friday, Your Lordship. Apply.
May I please, your lordship? Item number 5 to 12, your lordship.
Yes.
I may be allowed to withdraw, my lord. The appeal is pending before Appellate Tribunal, Calcutta, my lord. Only prayer is, my lord, liberty may be granted after disposal of, I may be
That you
allowed,
already have heard Miss S.S.G.R.
my lord.
learned counsel for the petitioners in these cases, also heard Sri S.C. Kyle, learned senior standing counsel, CGST, CGST Customs. Where Miss Gia, the learned counsel, has submitted that in view of the appeal which is pending, a pending adjudication, she would not like to press these writ petitions. She has, however, prayed for a liberty to approach this court in case of any grievance after disposal of the appeal. Para? In view of the aforesaid submission, writ petitions are dismissed on withdrawal if liberty has paid for.
Highly obliged, ma'am.
First, 5 to
12, my lord.
okay.
May it please your lordship, I beg to mention item number 66 of supplementary list, my lord.
Yes.
Here in this matter, my lord, we need some time to file reply to the affidavit in opposition, my lord. So kindly 2 weeks time may be given.
You're for respondent number 6.
I am for the petitioner, my lord.
You're for the petitioner.
Yes, your lord.
Number 6, 7, and 8.
You need time to file rejoinder affidavit. What
Yes,
is your name, madam? What is your name?
SC Murtaja on behalf of R. Chaudhary.
You are SC Murtaza.
Yes, your lordship.
On the prayer of Miss S.C. Murtaza, learned counsel, appearing on instruction of Miss R. Chaudhary, learned counsel for the petitioners. Matter is adjourned by 2 weeks.
Yes, your lordship.
2 weeks to enable filing of rejoinder affidavit. List on, we give a date. 2 weeks, today is 11th, 1, 2. We'll have it on 27th of March, okay?
Obliged.
No interim order, madam? Is there an interim order?
No, your lordship.
Okay, yes.
May I please, Your Lordship? Lordship, I beg to mention a writ petition matter, old writ petition.
Of which year?
My lord, it's of 2023, my lord.
23. 23 is old.
My lord, but it's a very concise matter, my lord, settlement, and then some portion of land has been untraceable. And the respondents are seeking time over time. So, my lord, on the 16th, the admission.
Difficult. Not a matter to be listed by mention memo. Sorry. Yes.
Lordship, with the consent of other side, I would like to mention item 45. May the matter be listed after 2 weeks. I would file an additional affidavit in this matter.
45. There is an IA also. filed.
I am for the IA, Lordship.
Okay, you need to file additional affidavit. Yes, who is for the other side informed?
Yes. With
What
the-
is your name?
My Dr. DJ Deca.
On the prayer of Dr. DJ Decal, learned counsel for the applicant. 2 weeks further time is granted to file additional affidavit. List on 25/3. Is there any interim order?
No, Lordship.
I is for what?
I is to implead me as a party.
Okay.
With the consent of the other side, my lord, I beg to mention item 36, my lord,
26,
36, my lord.
36.
Lordship, in this matter, my lord, BPC is required to obtain some updated instruction, my lord. Although affidavit has been filed by us, updated instruction is required.
And from the other side, have you-
Yes, yes. You need to come
on a request made by Ms. B. Bora, learned standing counsel BTC. Matter is adjourned by 3 weeks to enable her to obtain further instructions in this matter. List on the 1st of April,
I'm on.
1/4. Is there any interim order, madam? Yes.
For listing of a contempt case, your lordship, it was last listed on 16 to your lordship.
What is the urgency in a contempt?
Your lordship, only 2 days has been there.
Sorry, not a matter of mention memo listing, sorry, only urgent matters. Yes, madam.
May I please your lordship?
May I please
Yes.
check for discriminatory petition, Lordship?
Motion,
Motion for motion.
when?
Friday, Lordship.
Okay, yes.
May I please your lordship? Lordship, I beg to mention item number 51.
51. Speak a bit loud, madam. You are not audible. Yes, 51. What do you want?
Matter may be taken after 1 week.
After 1 week. Why?
Lordship, some personal difficulties.
Hmm?
Some personal difficulties.
Oh, whose personal difficulty?
HRS authority.
Okay, IA is for what? What is the IA file for? There is an IA interlocutory application. What is what? Hmm?
We are challenging the order, lordship.
No, no, IA is for what? This is an IA. What is the interlocutory application file for? No idea. You should have some idea. Madam, you should have some idea at least when you mention. Why is the case filed for? What is the subject matter involved? Okay, on a request made on behalf of Sri H.R.A. Chaudhary, learned senior counsel for the applicant matter. Have you taken the consent of the other side?
No, lordship.
You have to take the consent. Don't make a mention. You're new counsel. There are certain procedures. Take the consent, then make a mention. We'll allow it, but not now. Take the consent and come. Yes.
Item 1.
May it please your lordship. Lordship, this matter challenges the illegal action of the respondent authorities in conducting search and seizure proceedings at the place of business of the petitioner, your lordship. Lordship, unfortunately, we have not been able to establish contact with the petitioner, client, your lordship. We will be filing a letter informing that we'll be withdrawing from the matter, your lordship. This matter last came up in 23 August, your lordship.
We'll close this. We'll give liberty to come if there is any fresh cause of action. Okay.
Lordship.
What is your name?
A. Goswami, on behalf of P. Mohan.
On behalf of P. Mahanto. Okay. Sri A. Goswami, learned counsel for the petitioner, learned counsel appearing on instruction of Sri P. Mahanto, learned counsel for the petitioner, has submitted that there is no contact with the client and the matter was last listed on 7/8/2023. Also heard Sri H. Barua, learned counsel appearing on behalf of the Finance Department. Para? Finance Taxation Department. Para? In view of the above, comma, the matter stands closed. However, liberty is granted to the petitioner in case there is any subsisting cause of action.
Right.
Item 2.
Also, this is the matter in regards to the non-registration of the FIR after continuous effort. And the other side, they appeared and the last occasion, they were asked to take instructions with regard to the GD entry, without the GD entry, how the inquiry was being made.
Yes, Mr.
That case was registered and has been investigated upon. It's still on investigation. Case, Doboka PS case number 146.
What are the sections involved?
Section 143, 342.
You're Ahmed, S. Ahmed.
Yes.
What are the sections involved?
Lordship,
What is the offense?
The offense, they were being hit on the roadside. It was dragged. The registration of the FIR, didn't
Serious-
have any knowledge in the regard to this.
Serious offense.
Initially,
But, okay, now it has been registered. Okay, we'll complete the investigation in accordance with law. We'll close this then. Heard Sri S. Ahmed, learned counsel for the petitioner, also heard Sri B.J. Talukdar, learned additional senior government advocate assisted by Sri P.K. Medhi. Full stop para. The writ petition was instituted with the aforesaid prayer 11, na? Page 11, quote kar dijiye. Para. Sri Talukdar, the learned state council has submitted that the FIR, that the Ajahar has indeed been registered and as Doboka PS case number
PS case number 146 of 2024.
146 of 2024 and investigation is still on.
Still.
Full stop. Para. While para. In view of the above development, comma, while this court is of the opinion that the primary grievance of the petitioner has been redressed, comma, it is directed. This court has observed that the investigation has not been completed in spite of elapse of a considerable length of time. Full stop. In that view of the matter, while this writ petition is closed, direction is given for expeditious completion of the investigation in accordance with law.
May it please your lordship.
Yes.
Your lordship will kindly peruse the order dated 4/11/2025. Has your lordship?
Yes, what is your instruction?
My lord, that attachment order has been issued. That was our last instruction, now 25.
25 to that you have already placed on record.
Yeah, after we have got this.
No, the date was fixed on 6/3.
Your
What
lord-
happened on 6/3?
Nothing happened, your lordship. May I just place the facts, your
No,
lordship?
we know the facts, Mr.
No, when I say the facts, I mean what the direction of the court
No,
was.
we have seen the direction. This is not come up for the first time.
Your lordship, there,
6/3, nothing has happened. Why? This matter has been dragging.
I am told that warrant was issued.
No, warrant of attachment of immovable property was issued on 25/2, fixing on 6/3.
Yeah, after I had not received such, lordship,
You get this 6, today is what? Today is 11th.
11.
That is why we had put the date today, so that after 6/3, you get adequate time to have the instructions. You get the instructions, we'll have it on Tuesday next, or Wednesday next.
your lordship, the direction was there from the honorable court directed them to complete the procedure within 90 days. It was they who said that they'll require 90 days. And accordingly, the court on 6/11/2025 fixed the case on 26 to 2026.
Okay, we get the instructions, okay. Heard 3 hours in a learned counsel for the petitioner. Full stop. Right, the last order dated 26 to 2026, this court had recorded the submission made on behalf of the state that an warrant of attachment of immovable property was issued by the District Commissioner Kamrup M on 25/2/2026, and the date was fixed on 6/3/2026. Full stop. Accordingly, the matter was fixed. Matter was directed to be listed today. Full stop. Para. Sri B.J. Talukdar, learned additional senior advocate assisted by Sri P.K. Medhi, has however sought for some more time to obtain the instructions as instruction with regard to the development on 6/3/2026. Para. Considering the subject matter involved, comma, a short time is granted directing listing of this matter on 18th of March, 18 March. Please get these instructions. Otherwise, we'll have to take some other recourse.
Deeply obliged.
I will go.
May it please your lordship.
Yes.
Lordship, the directions, the effective directions, lordship, content in lordship, page number 36, your lordship. Starts from the last line, lordship. So before coming to the direction, lordship, may I submit a bit of text, your lordship?
Facts are not required, Mr. Das. Where are the direction?
Lordship, page 36, para 37, lordship, the last para. In view of the discussion made herein above, I am of the view that the deputy commissioner district may I read, lordship?
Paragraph 37.
37, your lordship.
I am of the Deputy Commissioner, District Commissioner. Now, how is it being violated?
Lordship, because lordship, that's why lordship may come to page 32, lordship. That is the one of the notification, because two notification challenge in different, in two petitions, your lordship.
Yes.
Two orders were challenged, page
Yes.
32. The extracted portion of the notification order is lordship quoted here in lordship, page 32.
Yes.
para 27, to appreciate, I deem it apposite to refer to the impugned order dated 24/7/2018 passed by the DC, and the same is reproduced herein below. Lordship may come to the order, Lordship. Number 2, land status of the property and other assets both movable and immovable thereof, functioning of the management committee it in force. Lordship, now what happened, Lordship? And there is this is of 24/7/2018. There was subsequent, Lordship, that will come to know in para 29, Lordship, page 33. A subsequent order was also issued, Lordship.
Now, what is the contempt? Let us see what is the contempt.
Yes.
What has happened
So,
thereafter?
Lordship, in the subsequent order, Lordship, of 16/8/2018, a committee was formed by the ADC, Your Lordship, where, Lordship, the private respondent, I made them also.
So, Das, you tell us how is it how is it being violated? Tell us that. You
Yes,
don't
Lord.
go to the background history.
Okay.
We have seen
Yes,
the interference of this court. Now, what has happened?
Lordship may come to page 39, Your Lordship,
39.
39.
Yes.
There are subsequent orders also, Lordship.
Yes.
This is one of the member of the committee formed by the ADC, Lordship, on the behest of the order dated 16/8/2018. So he is trying to grab the land, Lordship, showing that they are the management, they are the managing committee. Now they have already cancelled the electricity connection also, and they have transferred it to their name.
Where have we
mining.
stated?
I have stated there in the paragraph, Your Lordship. Para 9, Your Lordship, page 9. The petitioner begs to state that despite the judgment and order dated 25/2/2025 passed in so and so, the authority in the district administration has not taken any measure to prevent from interfering into the affairs of the Thakurbari. Moreover, respondent content number 4 to 12, these are the private respondents, Lordship, is still interfering in the affairs of the Thakurbari at the behest of the impugned order dated 16/8/2018, which is admittedly set aside and quashed by the Honorable Court. Initially, at the strength of the order dated 16/8/2018, passed by the ADC, the respondent was invaded some rooms which are in the premise of the Thakurbari and stated.
But these actions were a long time back. When have you come to the court?
Lordship, actually, Lordship, the order was passed on 25/2/2025. Lordship, I filed it just before the expiry of the 1 year, Lordship, because I was still in the hope that
When did you file this?
Lordship, on 23rd, Lordship. 22nd, Lordship, maybe. Because I'm still,
But
because
these averments of allegations of violation,
Lordship,
this pertains to which period? Kindly come to page 10.
Lordship,
These are of 2024, your letters.
yes, Lordship, 2024, but the authorities ought to, and thereafter, Lordship, I intimated the authorities to change to stop them from interfering in the affairs, Lordship, but still they are interfering, Lordship, and they are collecting rents also, Lordship. That I've stated, Lordship, still they on date also they are collecting rents.
You have not given any details. Who's collecting rent from whom?
Lordship, in that
No,
case, Lordship,
no,
give me 1 week time, Lordship, I'll bring
No
in
dates. You can kindly come to paragraph 9.
Lordship.
9 has mentioned the date of 15/2/2024, which is prior to the judgment.
Lordship, that's correct, Lordship, but
You have
it is
to
a
make out a
continuous course
case.
of action, Lordship. That's continuously it's happening, Lordship, till date.
Where have you stated which date the rent has been collected, collected by whom? Which of the respondents? Who are the respondents
Lordship,
here?
respondent number 4 to 12, Your Lordship. These are the members that
You
were,
have to file an additional affidavit.
yes, Lordship, I'll bring it on record of some photographs and some subsequent.
Harshri DJ Das, learned counsel for the petitioner, who by means of this petition has complained of willful and deliberate violation of the judgment and order dated 25/2/2025 passed in so and so, full stop. While certain averments have been made in paragraph 9 regarding the aspect of violation, comma, the same lacks the details more particularly of the period on which such violation has taken place, full stop. This court has also noted that reliance has been placed on a letter dated 15/2/2024, which is even prior to the judgment in question. Put the para. At this stage, Sri Das, the learned counsel, prays for some time to file additional affidavit to substantiate his allegations. Put the para. 1 week or 2 weeks?
Lordship, 1 week, Lordship.
Let this matter be, the matter according to stands adjourned by a week to enable filing of additional affidavit.
Lordship, also, may I bring out to record, Lordship, may I edit to the order, Lordship, page 43, Your Lordship. That is subsequent to this order, Your Lordship. May I just
43.
Yes, Lordship. I'm sorry for apology.
43, where is the averment?
Averment is there, Your Lordship.
Who is this, Jayaprakash?
This is one of the members, same Lordship. This is one of the contender from, this is the same member, Lordship.
Petitioner.
No, this is the respondent, Lordship. So they are using the name of the trust, Lordship, and they are trying to show that, Lordship, that they are the management committee and the petitioner is nowhere, Lordship. They are trying to impose authority upon the Thakurbari, Your Lordship. This is of 3rd September 2025, Lordship. Now they have started using the Sri Sitaram Thakurbari Trust. Now, one of my person is staying there, Lordship, and they are trying to evict him from the premise, Lordship, and that's why they have filed this FIR, Lordship. Kindly see, Lordship, in page 43. Yesterday, when we
Where is
started,
your averment? Averment.
page 11, para 11, Your Lordship. That the petitioner begs to state that on 3/9/2025, the respondent contender, namely Sri So-and-so, filed an FIR before the Fancy Bazaar police station in a letterhead reflecting.
Thereafter, what has happened?
Lordship, now the police that I have no instruction, Lordship, but I got.
See, somebody is doing some mischief. Will it amount to contempt?
But
Contempt is violation of the order.
on the behest of that.
Using your name may not be contempt per se.
No,
You will have other remedies in law.
they started using the name on the virtue of the order that was passed by the ADC, Lordship, and still they have not cancelled that order, Lordship. They have not cancelled it.
No, where is the requirement to cancel when the order was set aside by the court?
But the committee.
Is there
was
any
formed.
requirement for a subsequent or a consequential order of cancellation? Order was interfered by this court.
Yes, Lordship, that I really appreciate that, Lordship, but the order was, though it was set aside, but in the meantime, the
Mr.
committee was already formed, Your Lordship. The committee has
Mr.
not
Das,
dissolved
you
yet.
come prepared. We'll hear it tomorrow.
Yes, Lordship, after 1 week. Lordship, I'll
No,
bring
not 1 week. No need to file a detailed affidavit. You come prepared. You be specific on the allegation.
Yes, Lordship.
Okay.
I'll bring some points in the additional affidavit also, Lordship.
If you want to file additional
Yes,
affidavit,
It will help for the honorable court, Your Lord.
DJ Das. Last. Substantial grievance. Accordingly, last में बोला ना कुछ? Additional affidavit. We give you, we have it on Wednesday next.
Much obliged.
You be specific on your allegation. This is the order of this court. This is the violation.
Yes, Lordship.
For issuance of notice, this is not so difficult.
Understand, Your Lordship. Much obliged.
Item 30. Here I pay for some 1 week time, more time, Lordship, we have not received the instruction.
This is a motion.
Lordship.
What is the matter, madam?
Matter relates to Lordship, petitioner's husband, predecessor was the owner of was a pattadar of a plot of land 6 biga 3 gatha, Lordship. Then their legal heir applied for mutation in their name as the legal process of legal heir. Then the revenue authority not issued as stated that wrongly applied the land in concern is subsidized. Hence, mutation may not be accorded till.
Where is it subjudice?
Some cases pending, they have stated.
But Lordship, I have applied Form 50 and no litigation is pending till 7/11/22 to 6/11/25.
will issue notice at this stage. Why should be at the instructions? What is your name, madam?
NJ Begum, Lordship. NJ Begum.
MZ.
NJ.
NJ. Heard Miss NJ Begum, learned counsel for the petitioners who are aggrieved by rejection of their application for mutation of a plot of land. It is contended that their predecessor, late Saifuddin Ahmed, was a patadar of a plot of land, and after his demise on 31/10/2024, the petitioners had submitted an application on 22/2/2025 online for mutation, which has been wrongly rejected. Spara, let it is specifically contended that though there is an indication that the land is the subject matter of some litigation, there is no litigation pending to the knowledge of the petitioners. Para, that notice be issued. You are not on record, madam,
No, Lordship, I'm on behalf of S.H. Sigdar, Lordship.
on behalf of SSC, no? Let notice be issued, returnable on returnable on 8th of April. 8th of April. Madam Hazarika, 1,
I am for 2, 3, and 4.
2, 3, and 4. Perhaps extra copy was already submitted.
Yes.
Okay. Extra copies.
Lordship. I'm obliged.
14.
Yes, Mr. Chaudhary? Yes.
This case is relating to a provincialization service of the petitioner, Your Lordship. The petitioner services was not provincialized, but the phone numbers of teachers were provincialized.
This is a bench, which bench? Bench 2, perhaps? 2.
But earlier,
Provincial in the service of teachers.
there are also regarding land also. He has donated the land to the authorities, Your Lordship. But for the provincialization of school, Your Lordship will find.
This will be, I think, bench 2 matter.
The dispute is regarding the land, my lord.
My lord,
For provincialization.
my lord, mainly land, Your Lordship. They have.
What is it? Yes, what is the dispute?
So, my lord. Dispute,
Yes, what has happened actually? Tell us.
my lord.
How many of you are there? One petitioner.
My lord, only one petitioner. These
Okay.
services were not provincialized, but the other 4 teachers are provincialized. But due to the there is an agreement, Your Lordship, that regarding the provincialization of service of the petitioner, Your Lordship.
Revert back
But-
the donated land.
My lord, donated land, they have taken the land, but instead of my services were not provincialized.
But can it be a ground? It's not a quid pro quo.
My lord, I have
You donate land, you'll get services provincialized.
there is an agreement, Your Lordship.
Are these agreements enforceable in law?
My lord,
Anyone can donate land and get a job.
I have submitted a representation before the authorities, my lord, that may be considered, you may be directed to
But what is
consider.
your enforceable
I have-
right, Mr. Chaudhary?
My
Just-
lord, I
You
have
have to
submitted
make out a case that there is a right has been violated.
my representation, Your Lordship, will find page
Yes, what is your stand?
my
BTC.
simple prayer, my lord,
Reasonable
page
matter.
28.
The civil nature dispute. Of civil nature.
As I have submitted representation, that may be disposed of, my lord. My simple prayer, Your Lordship.
For that prayer, we are not acceding to those kind of prayers, disposal of representation. Sorry.
My lord.
This is not a writ code for directing disposal for representation. You have to make out an enforceable case.
My lord. I have the
We don't
case,
give a handle like this. Make out a
Then-
case, take an order.
my lord. Then-
You donated land for provincialization. Is it an enforceable agreement?
My lord. As a, there
Is it recognized by
Yes.
law?
the school has taken my land, Your Lordship, for the provincialization of my service, Your Lordship. But they neither
Mr.
they
Mr.
provincialization of
Chaudhary, answer the
lord.
question.
my lord.
can services be provincialized in lieu of taking land?
my lord.
Or will it be
But-
provincialized in accordance with law?
But instead of that, they have taken the land, but neither my
These are not
my
enforceable
post has been
agreements.
provincialized or revert back my land. My only problem is to direction will be given to revert back my land, your lordship. Simple prayer, your lordship. As I have submitted a
You have to
representation,
go to,
your
you have to go
lordship,
to the civil court.
my lord.
You have to, if you are enforcing your, some agreement which prima facie does not appear to be legally enforceable,
My lord.
how can a writ court help you?
But your lordship will find a page 27, your lordship.
27.
27,
Yes, please.
there is a certificate, your lordship.
What is the certificate?
May I read it?
Yes.
This is to certify that Kawemari Emi Madrasa School is situated at a plot of land measuring 3 biga 2 kotha 10 lesa has been running in village Kawemari Moja, Govardhana under the Jala Revenue Circle in the district of Baksa, BTR, Assam. Schedule area of land 3 biga 2 kotha 10 lesa, patta number so and so, dag number so and so, village Kawemari Moja, Govardhana.
This is not in dispute. Who is disputing this?
But instead of that, they have taken the land, neither my service has been provincialized, my lord. That is, I have submitted a representation before the authority, my lord.
Difficult case. Heard Sri R.M. Chaudhary, learned counsel for the petitioner. First up, as per the facts projected, the petitioner was appointed in a grade 4 post in the BKME Madrasa on 1/9/1994 as per resolution of the managing committee. How can the resolution be of 2003 if you were appointed in 1994?
My lord, that is, they have taken the resolution.
How can a resolution be of a later date? That is the question. You said you have been appointed on 1/1/1994.
My lord.
Resolution has to be prior to 1/1/94. You have written 22nd December 2003.
No, in 2024, my lord, they have taken the resolution. 24, your lord.
Now come to the first line of your synopsis, Mr. Chaudhary.
No, my lord,
Synopsis, first line.
page 27, your lord.
In the synopsis, you have stated that you are appointed on 1/1/1994
That is,
as per a resolution dated 22nd of December 2003. How is it
My lord.
possible?
that is the appointment, your lordship. That is the appointment.
So how can a resolution be of a later date?
Your lordship may kindly take it another day. I shall.
Lordship, also in the
con-
agreement, my lord, there is no authorization or.
No, those are besides the point. But there has to be a resolution has to be of a prior date.
Let
there is
me-
no
let-
resolution.
Let me hard on another day. your
Monday.
lordship.
Monday.
Monday.
On the request of Sri R.M. Chaudhary, learned counsel for the petitioner. Matter is adjourned to be listed on Monday. Please give the date.
I did 15 and 63.
15 and 63.
Your
Yes,
lordship,
what is this?
may it please your lordship.
Yes.
Lordship, the IA has been completed and
I is for
was for
implement.
adding NHAI as a party.
We file, we first consider your I. Okay. What is your name? Your name?
IS Mazhar Bhuya, your lordship.
I.S. Mazhar. Heard Sri I.S. Mazhar Bhuya, learned counsel for the applicant, who by means of this application has prayed for implement of two incumbents as respondent numbers 5 and 6, which are as follows. दोनों incumbents का नाम लिख दीजिए, हाँ? यहाँ. Schedule C. Yeah, page 4 and 5. You don't put in a schedule. That is not what is prescribed. Not required. It's not a plaint. You put in the part of the pleadings. in a separate paragraph. Okay, there is no requirement of schedule. The learned counsel has submitted that presence of the aforesaid incumbents would be necessary for complete adjudication of the matter which has been raised in the connected WPC 1138 of 2026. First of, after considering, the IA stands allowed and the incumbents named above are implemented as respond numbers 5 and 6. IA stands disposed of. In the writ petition, you write. An order has been passed today in I 796/2026, implementing the following incumbents as respond numbers 5 and 6. Put the naam likh dijiye, haan? The learned counsel, Sri I.S. Major for the petitioner is directed to file amended cost title and the matter be listed for motion along with such amended cost title. When can you file? You file it by 2 days, it'll be in the next week. Next Wednesday we are taking,
Lordship,
on Wednesday next.
obliged, your Lordship.
Did this then.
16.
There's a counsel who will appear online.
Online, item number,
16, Lord.
who is appearing, name?
The peak Purana, Lord.
May I please, your Lordship?
Yes, you're audible,
ma'am.
but we don't see you. You adjust your camera.
Yes, ma'am.
Yes. What
Yes,
is
ma'am.
it?
Well, this petition challenges, ma'am, the reassessment proceedings under the Income Tax Act. Plus, the notice was issued, and plus one of the issue which plus has already been decided by this honorable court, and also the interim orders have been granted in the similar petitions for the other years of the same petitioner, is the notice under 148 has to be under faceless manner and by a faceless assessment unit instead of the assessing officer. And it is the notice is at page 44.
But you are challenging the proceeding at the threshold. The notice itself is the subject matter of challenge.
That's right, ma'am. That
What
is without
what is the
jurisdiction.
scope of interference?
No, the scope of interference is there, Milad, because the notice itself is without jurisdiction and authority of law, contrary to their own statutory scheme, which says that a notice under 148 has to be through faceless mechanism. It can't be through the assessing officer. If your lordships peruse page 44 for a moment, your lordship will find
44.
the name of the assessing officer. Yes, page 44 and Annexure 5.
Yes, please.
Yes, Manoj. Because it has been issued to the petitioner, and your lordship will find the name of the assessing officer as John K. Gangte,
Yes.
ECIT Circle 2, Gauhati.
Yes.
And whereas, Manoj, as per the provisions of the Income Tax Act,
Yes.
and plus, if I can show it from the judgment itself passed by this honorable court, plus my
Yes.
colleague would hand over the judgment in the case of Ram Narayan Sa.
Okay.
Paragraph 6. Paragraph 6 records that section 151 capital A of the Income Tax Act provides as under. These are the provisions. And then para 7 records the notification,
Correct.
which has been passed pursuant to this provision,
Yes.
which says, on the next page, Malad would find para 3 clause B, I'm reading.
Yes.
For the purpose of this scheme, A, assessment, reassessment or recomputation under 147 of the Act. B, issuance of notice under 148 of the Act shall be through automated allocation in accordance with risk management strategy formulated by the board as referred to in section 148 of the Act for issuance of notice and in a faceless manner to the extent provided in section so and so with reference to making assessment or reassessment of total income or loss of assessee. Then my lords, para 9.
Yes.
Yes, my lords. Para 9, perusal of section 151A along with the
Yes, what do you say, Mr.
Your lordship, presently the issue, my lord, whether it can notice under section 148 can be issued by the jurisdictional assessing authority or the, my lord, faceless authority, my lord. It is presently pending before the Honorable Apex Court. At this stage, lordship may issue notice, my lord. Some other matters are also pending, my lord, on this issue. We'll file our affidavit.
Now, what is the objective of this particular provision in the statute to make it faceless?
Yes, lordship. So that, my lord, the entire proceeding, my lord, the assessee should not meet the officer, my lord, physically, my lord, and it is, my
To
lord,
maintain absolute transparency.
lord.
And
yes,
so
my lord,
that
and to maintain
the proceeding
and to
is not
achieve
vitiated by any
uniformity.
nepotism or anything.
My lord.
He's not. He
And
should not know that who is adjudicating the matter. It is to be an automated matter.
Lord.
Okay, at this stage we have to issue notice.
Lord.
my lords may also my lords, I request for interim stay. In
Let
the
us see, let
meanwhile,
us see. What is your name?
my lords, my
Your
name
name?
is Prakul Khurana.
P. Khurana.
Yes.
Heard Sri P. Khurana, learned counsel for the petitioner who has appeared online, along with Sri S.D. learned counsel who is present. Full stop. The challenge in this petition is against a notice dated 30/8/2024 issued under section 148 of the Income Tax Act 1961 for the assessment year 2018-19. Full stop. The challenge is also towards a letter dated 29/8/2025 and the consequential action thereafter. Full stop. It is contended that the proceeding has been initiated in contravention with law and there is a jurisdictional error. Full stop. He has also relied upon a judgment of a coordinate bench dated 25/2024 passed in WPC 2438 of 2024, wherein the aspect that a proceeding under section 148 has to be in an automated and faceless manner has also been highlighted. Post the para, let notice be issued. Returnable on, yes, date.
3 weeks.
Lords, may I request for the
Returnable,
interim.
give a date. Mr. Khurana, a date. We'll have it before the Bihu vacation.
6th.
No, very well, ma'am. The date is not a difficulty.
On 8th of April. On 8th of
Very well.
April, 2020.
Lords, may I request for the interim, my lords?
Yes,
For the similar.
Yes. So you will accept for all?
2 and 3.
CGC, any CGC? Central Government Council, anyone? Roy is there. Sri S.S. Roy, Leonard. CGC accepts notice on behalf of 1 and S. Chetty, Leonard, Standing Council, Income Tax Department for 2 and 3. Extra copies. Sri Khurana, the Learned Council prays for an interim order. Full stop. The same is, however, opposed by Sri Chetia, who has, however, full stop. He has, however, fairly submitted that the issue is presently pending consideration before the Honorable Apex Court. Full stop. Considering the above and to balance the equities, it is provided that till the returnable date, no coercive action in terms of the impugned notice be taken.
Plus further proceedings, because it has not culminated in the order. So, my lords, may only say further proceedings.
No coercive action. Don't take coercive action. What is the stage?
It is.
They have to file it. They have to file their.
No, the assessment order has not been passed.
But proceeding and status quo as on today be maintained.
Status quo as on the proceedings. Very well. I'm so grateful.
Agenda 17.
May I please, Your Lordship. It relates to the Golaghat Municipal Corporation, Lordship.
Municipal Board, Lordship.
That encroachment.
Lordship.
Yes, what is your instruction?
Lordship, that I have to take some time, Lordship. 10 days more time.
But we had also made an observation that pendency shall not be a bar for a negotiated settlement.
Yes, Lordship.
Have you talked? He was there.
Nothing has been done.
Lordship, so far, what
Okay.
happened, Lordship, we process to the circle officer because this.
Then let us issue a formal notice. There is some kind of an interim order, isn't it?
Lordship.
Will issue a formal notice. Okay. Heard Sri R. Bora, learned counsel for the petitioners. Full stop. The allegation in this petition was with regard to construction of a drain by the Golaghat Municipal Board,
Lordship.
which according to the petitioner was through his Miadi Pata land. Full stop. The matter was moved on 27/2/2026 when instructions were directed to be obtained on behalf of the Golaghat Municipal Board and an interim direction was issued for not to carry out further constructions till the next date. Full stop. On the next date, comma, the learned counsel for the board had obtained certain instructions as per which the entire land of the petitioner was not involved in the construction of the drain. Full stop. This court had accordingly modified the interim order that the same would remain operative only for the disputed area, which ranges to approximately 80 meters.
80 meters.
Full stop. Para. Sri J.K. Goswami, learned counsel appearing for the board, has prayed for some more time to obtain the instructions. Para, let notice be issued, returnable on 10th of April 2026. Yes, you will be accepting for all housing. One,
I will
two,
accept on this one 3 and 4, Lordship. Others will, Lordship, my
Okay.
learning friends.
Sri S.S. Roy, London State Council for 1, 2. J.K. Goswami for 3 and 4.
Yes.
Goswami, Roy for 5 and 6, 5 and 6 PWD. DNAT. DNAT Standing Council PWD for 6. I think extra copies were already furnished.
Lordship.
You give furnish extra copies.
Lordship, we'll furnish it. Lordship, the interim order.
Interim order passed earlier to continue till the next date of justice.
All right, Lordship.
18.
Well, in this case, actually, I will be relying on one of your lordship's judgment. It is about unilateral freezing of the bank account of mine without any notice, merely on it throwing of a complaint by the cybercrime. My lord, I am an account holder of
At this stage, who's State Bank of India?
state,
Why don't you serve a copy on one of the persons who regularly appeared and informally?
We had served SC, SBI is also showing. The SC name of the standing council, SBI, SC, SBI is also in the cause list.
You have served.
yes.
Served upon whom?
Somebody was there.
No, you served upon whom? We don't think there is any standing council. There are panel council.
Then
We'll set. My lord, I will have a.
No, issuing notice is not an issue at all. We can issue
I
notice.
have
But
a slight.
Mr. Barbara would perhaps pray for an interim order.
My lord, not the whole part of your judgment, my lord, that will require notice, but very reasonable interim order, lordship will sue if it can be given. Because I have not been able to pay my electricity bill and my lord water bill. My lord, account, my lord, I am a petty account, my lord. Occasionally, my lord, I engage in online gaming for entertainment, my lord. Actually, I don't approve this. I don't advise anyone.
What
This-
games do you play, Mr. Barbara?
That's not good. But that is going on, my lord. That is not banned in this country. That is not banned in this country. There is a betting act. Since, my lord, it is not illegal, nor I cheated anybody, my lord, by any fraudulent means. Bank account was suddenly freezed on my lord 31st July without notice. I visit the bank and bank says, gave me a letter, my lord, which is at page 16.
How much amount?
My lord, very mega amount, my lord. Total 710 rupees only.
Is the amount involved?
Amount involved.
How much account do you?
My lord, kindly have a look at page 16.
How much is the deposit?
Deposit is also 90, my lord. I am a petty man, my lord.
It's been
Some 80, 90,000, small amount. So question is, my lord, family is also dependent on me. This is a poor fellow, my lord. Shouldn't have gone for this gambling, I must say.
Thereafter, what happened?
But thereafter, my lord, I emailed to the, my lord, crime branch of Bangalore. Till date, my lord, account is still under freeze. Here, my lord, I'll refer to your lordship's, my lord, judgment, which is at page 20. Have a look, my lord. Lordship has referred to many other judgments of different high courts. Page 20 is your lordship's judgment. It starts at page 20.
Yes.
Lordship will come to here the Lordship discussed about various keeping in lieu disputed amounts allowing incumbents. Then Lordship referred to various other judgments of different high courts. Then Lordship.
Mr. Barbara, I will issue a short notice. You serve Dusty on the SBI. On their appearance, we'll pass this order.
My interim prayer.
No, on their appearance, we'll pass final orders. Today, it will be difficult.
If possible, I will give an indemnity to the bank.
Those will consider.
Any loss?
We will have it returnable 2 weeks. You serve Dusty.
And Lordship may consider the interim prayer on that date.
Oh, definitely.
My problem is that I have not been able to, my lord,
Third Street, AC. See, your freezing was in July 2025.
I went to the bank. Then
you came after how many months?
Then I gave letters to them.
Wait for 2 weeks.
Lordship.
Third Street, AC, Borbar, Senate Council, assisted by Sri M. Smith. Footstop. The grievance of the petitioner is with regard to freezing of his bank account number so and so maintained with the State Bank of India.
He branch to what?
Borpul branch. Jorhat. Full stop.
Without notice.
It has been submitted that such impugned action has been taken without any notice and appears to be on the basis of some complaint lodged by the cyber police.
Respond number 3.
Full stop. Para. Let notice be issued returnable on today. We'll have it on 1st of April. But you have to serve Dusty. But what about
on my lord, on the Bangalore party, my lord, registered post.
No, for the bank, we'll ask you to serve.
Bank, my lord.
Okay.
Bank is fine.
Steps by speed post with AD. Steps within 2 working days. Liberty is also granted to serve the respondent number 2 by Dusty service, which is to be routed, so and so, before the next date.
7th of April, my lord.
7th of April. We said 1st of April. You want 7?
No, 1st is all right.
If you want 7, you can have 7 also.
1st will all right, my lord.
7th. 7 April. That will be a week for motion. We can have it. 7 April. Okay. 2 will take by Dusty also. Okay. And file affidavit before the next date.
And
the prayer for interim order would be considered on the next date.
My lord, on 3, my lord, by registered post.
No, not 3. 1, 2, and 3 by speed post with AD. Now the present mode is speed post. Apart from that, for 2, Dusty service. Additionally.
Item 19.
May please, your lordship. Lordship, this is an account freezing case. My account has been frozen due to some online complaints. The bank is I have an account in the State Bank of India, lordship. It's a saving account. I have not been intimated. I have not been given any notice, lordship. The amount has not been disclosed to me. Neither any communication has been made to me. I have made multiple visits to the bank. I have made representation to the bank. However, there is no remedy to me, lordship. That's why I have approached this. the amount, the disputed amount has not been disclosed to me. Lordship.
Heard Sri K. Deka, learned counsel for the petitioner who is aggrieved by the freezing of the bank account of the petitioner maintained, account number so maintained with the Bechamari branch, Morigao of the State Bank of India. Full stop. It is submitted that there was no prior notice and no reasons have been disclosed for such impugned action. Full stop. You are appearing on behalf of whom?
Union of India.
Union of India, the party? Yes. Ah, okay. Let notice be issued, returnable on 8th of April 2026. Your name? You are a CGC?
I'm serious.
S. Kakoti, CGC for Union of India. And 2 by speed post with AD. Steps within 2 days.
Lordship, for statement, dusting may be permitted, Lordship. For the respondent number 2, dusting may be permitted.
You want to, okay, we'll assume Dusty, okay? Respondent number 2.
And,
Interim prayer will be considered on
for
the.
the respondent number, I am handing over the petition.
Yes, yes. But Dusty service, you take steps immediately.
Yes, Lordship.
Okay. Which branch? Morigaon.
It's in Nogao, Lordship, Bechamari, Nogao.
Okay.
Lordship, it may permit item 21, similar issue.
21. Which way? Same party?
No, it's a IndusInd Bank. Yeah.
Well, come when the turn comes.
20 and 20.
Yes, madam.
May please, your lordship, kindly pass over the matter for time being. Because of
Time being?
yes,
Why time being on whose behalf you are making a mention?
on behalf of SI account. The leading counsel is SI account.
Will issue notice, madam. What is your name?
S Khatun.
S. Khatun, are you there on record?
No.
You heard Miss S. Khatun, learned counsel appearing on instruction. Do you know the facts?
Yes.
What are the facts?
The husband of the petitioner was killed by the accused, therefore filed an application on 29/11/2005. As per the Assam compensation scheme, but it is not considered yet.
There is a scheme
Yes,
which provides what?
compensation.
For? Compensation for what? To whom?
Petitioner.
Petitioner, to whom? To what class of people? To victims?
Yes.
Okay. As per the facts projected, the husband of the petitioner was murdered on 11/3/2024. Is there any police case?
Yes.
For which a police case was registered and charge sheet filed, and the trial is on. Full stop. The grievance is towards non-receipt of the victim compensation under the Assam Victim Compensation Scheme notified on 18/10/2012 as amended on 1/2/2019. Full stop, Sarah. That notice be issued. Returnable on 10th of April.
Except for 1 and
One you can take, home and political.
1 and 4.
You can take 1 and 4. 1 and 4. What about the Salsa? Where is Miss Chaudhary? R.S. Chaudhary. So served or not?
Name shown.
Name shown.
2 and 3.
There is one Mr. Chauhan also, R. Chauhan. Where is he? What about 3? 3 has to go by speed post,
Lordship, they take this, Lordship.
even for district.
Yes.
Though the learned standing counsel Asalsa is not present in the court, notice extra copies, no extra copies of the petition may be served upon her. Para? কিমান কলো লিষ্ট ৰিটাৰ্নেবল কেতিয়া কলো
10.
নালাগে for 2 and 3 for 3 and
1 and 4.
you are for 1 and 4 for 2 and 3 2 and 3 standing council as also yes all of it would like to go that's the 2 1 and 2 1 and 4 and 2 and 3 by so and so whoever is not present in the court let extra copy this up okay same 21 is same
Yes, sir. The
which
slide,
bank
it's IndusInd Bank Lordship. The
I'll go
facts,
to Mr.
slightly, like difference in the facts Lordship, because in this I had opened an online account. So the main branch was in Gauhati in Kolkata. However, my corresponding branch is in Nagaon Lordship. So I have received the communication and all my communications have been dealt in Nagaon branch Lordship, which is the respondent number 2.
all about it how it's free your kid a card learned counsel for the petitioner who has opened an online account online account being online savings account being account number so and so with the which branch
It's Lordship in Gauhati branch.
in the Gauhati branch
Yes, sir. Lord. Because at that particular
of the IndusInd Bank and operates through the Nagaon branch.
Yes, Lord.
Full stop. The grievance is towards the action of the bank to freeze the account, the aforesaid account on 27/6/2025. The special thing I can receive. That's what the notice is. Okay. Okay. You take steps. Who will who are the respondent? Let us see. Union of India, you will take? GPay go 1 and 2, 3. What about 4? Commissioner of Police?
Will serve it.
Coimbatore. Okay, 2, 3, 4 by Speed Post PTD.
Yes.
Dusty na lagi. We'll take Dusty, Mr. Deka, for Nagaon branch. Is it required? Not required. Returnable kolo na hoy? Kuman kolo return. Same returnable. 10-4 na 8-4 required. 8-4.
22.
May it please your lordship, and this matter relates to non-issuance of NOC for sale permission on the ground that the sale is between two different religious communities, my lord.
That there is a new SOP. Have you followed that new notification? That notification, not a new, it's almost
9/9/2025.
25. Sufficient time has elapsed. Have you applied by for fulfilling 9/9/2025?
I have applied on 3/2/26, my lord.
3/2. Probably she has.
It's only with 1 month left. Before 1 month, yes.
Heard. Miss S. Roy, learned counsel for the petitioner who is aggrieved by non-finalization of the application for grant of NOC, public sale permission for sale of land. Full stop. It is contended that pursuant to an agreement, the petitioner had applied on 3/2/2026
26, my lord.
for such NOC, which was also acknowledged. How much time is required?
As per section 21A of registration act, my lord, within 30 days NOC has to be issued, and if it is not issued, the deputy commissioner has to give a person speaking order.
More than a month has elapsed. Okay. She has further contended that there is a stipulation of finalization of the NOC within 30 days.
30 days.
Full stop, para. Let notice be issued.
My lord.
Returnable on.
Lordship. Petition is a hard patient, my lord, for some urgencies, my lord. Coordinate branches in this regard dispose of in such as in dispose of an petition.
Some instructions are required, madam.
And your lordship might give a short date.
Will give a short date, tell us.
And
Yes, all our official respondents, perhaps we can give a short date. Returnable on today's 11th, no? Well, can you have it on 27th, madam?
27 March.
27th, okay, 27th. Miss Hadarika for 1, 2, 3, 4 extra copies. Serve extra copies today itself. Pendency shall not be a bar for consideration of the application of the petitioner, strictly in accordance with law.
In this case, Lordship, the petitioner land of 1 bigha 1 katha 18 lesha, Lordship, out of 3 bigha 2 katha 11 lesha was acquired for construction of national highway, Lordship, 4-lane national highway, Lordship. Thereafter, the petitioner submitted representations before the respondent authorities to demarcate the remaining portion of land of the petitioner, Lordship. On the basis of the complaints and representation, Lordship, the respondent number 4, that is the circle officer, submitted a report before the respondent number 3, that is the additional deputy commissioner, Lordship. Kindly peruse page 31, Lordship.
Thereafter,
page 31, Lordship.
that has not been done.
Lordship, they have submitted, the respondent number 4 has submitted a report before the respondent number 3, Lordship. Page 31, Lordship.
11/6/2025.
23/8/2024, Lordship. First report, Lordship.
First, thereafter another report. 11/6.
Thereafter, another report was
Yes.
sent by the respondent number 4, Lordship.
Yes. Now what has happened?
Lordship, I was paid compensation of 1 bigha 1 katha 18 lesser, Lordship. My land was not demarcated. Now they are saying that they have acquired 3 bigha 2 katha of my land, Lordship, without my knowledge. I am presently residing there. I have only 11 lessers of land, Lordship.
Yes, Mr. Collector.
Acquiring agency is the additional district commissioner.
But if as per notice, the portion of the land was 1 bigha 1 katha 18 lecha, if you want to extend, you have to notify again. And more important is that he cannot be deprived of the due compensation.
Lordship.
Third, Sri P. Bodole, Learned Counsel for the petitioner. Full stop. As per the facts projected, the petitioner is the owner of a plot of land measuring 3 bigha 2 katha 11 lecha, which was at Vishwanath, which was the subject matter. A part of the land was the subject matter of acquisition for construction of the 4-lane national highway. And accordingly, the petitioner had also received the compensation.
Lordship.
Full stop. However, there was no demarcation done in spite of various representation and reports. It has also been alleged that the acquisition that the acquired land amounts to a larger area for which neither any notice nor any compensation has been paid. Para. Let notice be issued, returnable on 7th of all private official respondents.
Lordship, all official respondents.
On 7th of revenue, PR Mahanta 1 only, madam.
3 and 4.
SS Roy 2, 3 and 4. RK Tadudra standing cause NHI DCL. No, this is NHAI.
Lordship, represented by General Manager NHI DCL.
What is this? You have not made the first 105 properly described properly. NHI, how can it be represented by NHI DCL?
Lordship, I will correct it. Lordship.
For 5 bullies, 5 extra copies.
Lordship, pendency shall not be here.
For what?
If they want to make compensation, Lordship.
It will not help you.
Lordship.
It will not help you. There will be.
Is to publish, Lordship.
There has to be a notice published, then compensation paid.
Lordship.
We'll have a direction on the next day. Let him have the instructions. Okay.
Oblige your Lordship. 24.
Yes, Mr.
Mr. My lord, petitioner was served with recovery notice, my lord, page 14, my lord.
You are challenging recovery notice.
It was the order. After receipt of recovery notice, petitioner made a representation that the lordship will find at page
What
7.
are your grounds of challenge?
My ground of challenge is, my lord, this so-called notice and order was not served. After making the representation, they gave a copy. So they handed over a copy on the same day. That is on 3rd of February 2026, my lord. And from the order also, it appears that there is nothing on record to show that so-called was served, my lord. Even the order.
Yes,
also-
Mr. Kyle.
Lordship, order in original was served on the petition. Last week then I submitted the postal record. Now Lordship that same.
No, that postal record was not a confirmed service.
No, Lordship,
It was a record of sending by post.
yes, Lord. Thereafter they withdraw the petition and Lordship, now they have annexed the order in original.
That was served on 3/2/2026, my lord.
Order in original Lordship, there is a reason for it. They may have appeal.
See, if he is deprived in the original stage, see, he'll be prejudiced in filing an appeal. First, let him have the defense in the initial grounds, initial stage. It is only directing you to have a procedure which is fair and transparent.
Lordship.
In the last case, he has undertaken that within 7 days, he'll file it here. He is also equipped with the show cause notice now.
Now with the order, my lord.
He can file it. We'll interfere with the original order.
Lordship, that
He'll file his reply to the show cause. How many days? 7 days?
My lord. Now I am equipped with the order, only with the order, my lord, not the so-cause, my lord.
Where is the show cause?
That I am my condition, they were not served. That was my condition. Even the order itself, it does not show it was served, my lord.
You collect the order
My lord, I will collect.
like the last.
My lord.
Do you have a copy of the last order?
I can just in 1 minute I can provide, my lord.
Okay, try to have it.
My lord.
That matter is almost similar.
Almost similar. And in that case, order was not served. Here order was served after submission of the representation, my lord.
Okay. So we can follow that order.
Lordship.
Okay. Dispose of.
My
Give
lord,
the
I'm-
order, but before giving it to the furnishing to the court master, kindly have it approved by
My
Mr.
lord.
Kyle.
Lordship.
My lord.
Okay. RS Mr. SC Kyle, dispose of. Huh?
Much obliged, much.
Maybe five.
May 25.
May please, Lordship.
Yes, Mr. Hawk, what is
Lordship,
this?
Lordship, the petitioner filed an RTI application that is page 7, Lordship. And thereafter, this application was forwarded by the Additional District Commissioner, Lordship, that is page 9, Lordship, on 8/1/2026, Lordship. And thereafter, no communication or.
You have a
It
provision for second appeal.
Lordship,
Why don't you file a second appeal?
But- I have not been denied, Lordship.
No, but this is denial. Okay, Mr. Handik, look into it. We're issuing a short notice. Heard. It's not a rejection per se. It was directed, but now the ADC has not given him the information. That is your case.
Lordship, it was forwarded to the District Commissioner, response number 4, Lordship.
Okay. Heard Sri N. Hawk, Learned Counsel for the petitioner who is aggrieved by not providing of necessary information which he had applied under the RTI Act. Full stop. It is projected that an application under the said Act was submitted before the District Commissioner, Murigaon, on 5/1/2026. Whereafter the same was forwarded to the Co-District Commissioner Lahori Ghat by letter dated 8/1/2026 with a direction to provide the said information. Full stop. However, the information has not been provided to the petitioner till date. Let us see 8/1/2026.
Lordship, page 9, Lord.
9. Full stop para. Let notice be issued. Returnable on 7th of April 2026. 3 J. Hunting, Learned State Council for 1, 2,
All are
for all the respondents, extra copies. He has also raised an issue that the act in question provides for further appeal. Full stop. Take a second. Okay. Pendency of this petition shall not be a bar for acting in accordance with the communication dated 8/1/2026 in accordance with law. Acting on the. Okay.
26.
Mr.
The
Doctor?
matter relates to distribution, allocation and distribution of funds.
In words, different words.
To different local bodies, Jila Panchayat committees, basically. As per the.
Who are you?
I am, we are 5 members of 5 different Jila Panchayat committees.
Jila Panchayat
Jila Parishad constituencies. According to the relevant notification, the fund has to be allocated depending on the population ratio.
Now you are 5 Jila Parishads.
Yes.
JP.
Yes, JP, under Gwalpara Jila Parishad constituencies.
You are 5 constituencies.
5 members of 5 constituencies.
Okay.
Now, as per the prevalent operational guidelines, the fund has to be allocated based on the population ratio. Our grievance is that, Lordship, Annexure 3 will indicate that disregarding the population ratio, the funds have been allocated. The allocation has come in the month of February for the year 2025-26.
This February it has come.
Yes.
Okay. Yes, we'll issue notice, Mr.
Only thing is that if your Lordship makes an observation that pendency will not be a bar on their part to consider our allocation if they find it.
So whatever has been distributed this time, there perhaps interference will be difficult because these are all developmental activities. But your concern is to maintain a parity.
Yes.
And there should not be a discrimination in the allocation.
Yes.
But funds definitely would come next time also. If this present process has not been finalized, they can consider. It is under the 15th FC.
Yes. 15th FC.
Heard. Decided number 3.
My name has been wrongly shown below.
Okay. Heard Sri S. Datta, Learned Senior Counsel assisted by Sri
MS Mondal.
MS Mondal for the petitioners. What's the? The 5 petitioners are Jila Parishad members of the
Paragraph 5, your Lordship may kindly see page 7.
Okay. Of the Gwalpara Jila Parishad.
Yes. Gwalpara Jila Parishad constituency.
Gwalpara Jila. Their grievance is in respect of discrimination in allotment of funds for their developmental activities and various schemes. Full stop. It is submitted that funds have been made available in February 2026 under the 15th FC grants, which requires a proportionate distribution, and without taking into consideration the said aspect, there has been haphazard distribution and allocation to the whims and fancies of the of the authorities. Let notice be issued returnable on 7th of April 2026. Sri S. Datta, Standing Counsel PNRD for 1
and 3.
1 and 3. District Commissioner Gwalpara 2, J. Hunting. What about Gwalpara Jila Parishad?
My lord, represented by President.
Okay. 4 and 5 speed post to DD.
Yes.
Pendency of this petition shall not be a bar for consideration of the representation of the petitioners for allotment of appropriate funds to their respective constituencies. Bless you.
Lordship, in this matter, my senior name may be deleted. Specifically, Shishir Datta is reflecting Lordship in the court.
Office to correctly reflect the name of Sri Surajit Datta instead of Sri Shishir Datta in the court list.
Highly obliged.
27.
But GST cancellation, my lord.
Hmm?
Covered, GST cancellation is covered by Lordship order, my lord.
Something here being the preferred appeal date was dismissed as a time bomb. Against that, Lordship recognized under section 112 of the Affidavit. GST under section 112.
He had availed of the appellate
Yes.
forum.
That
Thereafter, can you parallelly come before the writ court for the same cause of action?
When this was appeal was dismissed on limitation, my lord, and Lordship has earlier passed orders, even if the appeal were dismissed, Lordship passed order for consideration, my lord.
Where is the scope of consideration?
Because, my lord, it does not merge with the appellate order, because it was dismissed on the point of limitation, saying that the authority.
Dismissal on limitation is not dismissal on merits.
But, my lord, there is a judgment, my lord, it says, my lord, since it was dismissed because of fact, not because of the delay lectures, because of the, there does not have power to condone the delay, my lord. That was the reason.
See, Mr. Mishra, law is very clear. Whether it is dismissed on merits or dismissed on limitation, it is a dismissal on merits. It has to deem to be that. Now, there has been an adjudication of your claim, even at the appellate forum. Now, can it be reopened in a parallel proceeding under 226? Question will be slightly different.
This is justice revived, my lord, then the question of prejudice will come, my lord. It will not prejudice to government, because if I will justice revised, my lord, revived, then I will be in the business, my lord.
No, those are there, but what about the procedure?
I will be then remittless, because further again this will be dismissed because it's time barred, my lord. I will be.
What about the second appeal? You can convince the second appeal.
Even if I go for second appeal also, my lord.
Yes. Second appeal is not time barred.
No, but they don't have power, my lord, because this first appeal was dismissed only on the point of limitation for the purpose that it was they don't have the power to condone delay, my lord. Now I have to challenge the original order. Original order I cannot challenge before second appeal, my lord. That is the difficulty I have, my lord. So appellate order is as per law, because they don't have the power to condone delay. And original order I cannot challenge before the
Now
second
see,
appeal.
Mr. Mishra, now presently you are not remediless.
My lord.
What will happen in the second appeal? That is only a contemplation, speculation.
My lord.
If you exhaust your remedy in the second appeal, then you can very well make a contention that I am now without any remedy. So you can approach the 226.
My lord.
Now you have already taken that road towards filing of an appeal. Appeal gets dismissed. There is a second appeal. Mr.
But regarding prejudice, my lord. If it is revived, my lord.
Now second appellate tribunal is already started consent.
The judgment Lordship has passed orders earlier also, my lord. Even if after dismissal of appeal, Lordship has directed him to consider, because
At the relevant time, Lordship, there was no appellate tribunal. From 20th of January started consent.
But no fact.
Ultimately, Mr. Kyle has got a point.
That is true, but
after all these cases.
But the thing is that, my lord, how they will prejudice? The thing is that, my lord, if it is revived, they will not prejudice, my lord. The thing is that, my lord.
No, we'll come to the aspect of prejudice later on. First, what about the procedural aspect? And it's not a case that you had not gone for the appellate forum. You had gone for appellate forum.
My lord. That has
Your
gone
appeal
for.
got dismissed.
My
You
lord.
knew that it was time, but there is no power for condemnation.
My lord.
You could have come to red court then only, that I cannot go to the appeal.
My lord.
Yes, can something be done, Mr. Kyle?
Let's say beyond the law, I cannot make any sense.
Like, what is that earlier order?
So they allow their repetition, but at the relevant time, let's say there was no appellate tribunal.
But the direction is that to make payment all the.
But the council of tribunal was not struck.
But Mr. Mishra,
My
on substantive consideration, the matter was decided, and now the order by this court is only for reconsideration.
My
Now, once it was considered and rejected, how can they do it again? That is the question.
But my lordship has passed the order, not on merit. The lordship says, let them pay all the taxes and dues. If these are paid, it may revive, my lord. Not on the merit. Lordship has said, whatever, if there was some default on my part, I have missed the, I've done the default, my lord.
No, see, paragraph 13 is not that. Paragraph 13 says,
My lord.
writ petition is disposed of by providing that the petitioner shall approach the concerned authority in a period of 2 months from today, seeking restoration of GST. If the petitioner submits such application and complies with all the requirements, the authorities shall consider the application of the petitioner for restoration in accordance with law.
My lord.
It's only a consideration
My
order.
lord,
Now,
but-
consideration already been done
But-
and rejected.
It was on merit, my lord. It was on merit. It was.
Okay, দেখি বলুন। Kyle Leonard Council has however submitted that the aforesaid order may not be applicable in as much as in that case, the second appellate forum was not functional, whereas presently there is a second appellate forum which is which is functioning. We'll pass the same order, okay? Though Mr. Kyle would be correct, may be correct in the aforesaid contention, this court has taken into consideration that the dismissal by the first appellate tribunal was on the ground of limitation and not on merits. And therefore, in exercise of the extraordinary jurisdiction, the present order has been passed. Okay, make the correction.
Much obliged.
That Sri Kyle has raised an objection that in this case, an appeal was deferred, which was also dismissed on. Dismissed on
25 to 2026.
25 to 2026, and there is a forum, there is a provision for filing a second appeal. One will item here. Dispose of.
Item 28.
Please, your lordship. Hearing the name of the respondent number 2 is erroneous, lordship. So may I kindly be allowed to correct it through a, I'll file an IA for this.
Okay.
Respondent number 2.
As the learned counsel for the petitioner has submitted that while arraying the parties, there an inadvertent error has crept in the description of the respondent number 2. He accordingly pays for an opportunity to correct water secretariat,
Lordship.
correct the same full stop. Let application, that appropriate application be filed, whereafter this matter be listed.
Much obliged. Item 29.
Well, the petitioner is a proprietor of a concerned mirror, and by an adjudication order mirror, tax, interest and penalty was imposed on the concerned mirror. But side by side mirror, the penalty was also imposed under section 122(1)(a) on the proprietor. Because the concerned and proprietor are one and the same, because there is no separate entity. Now, the lordship can see the proprietor concerned finding, you also find at page 769 of volume 2 middle.
This is the.
But you are at the stage of challenging the show cause notice.
No, adjudication order.
Adjudication has been done.
Valid.
Now the demand has been made.
But I'm challenging on three grounds, my lord. That the 122(1)(a) penalty has been imposed for the years 2018-19 to 2021-22. Now, the 122(1)(a) itself was inserted from 1/1/2021.
Inserted on?
1/1/2021.
Okay.
So the penalty prior to 1/1/2021 is illegal. Secondly, my lord, my ground of challenge is that, my lord, that the proprietors of concern and the concern are no different entity. Now, once penalty has been imposed on the concern under section 74 of the CGST Act, the penalty on the proprietor separately cannot be imposed under section 122 of the Act, as the same is hit by section 127 of the Act. 127 says, my lord, that if penalty has been imposed, not imposed under section 74, that penalty can be imposed under section 122. So
122.
122, my lord.
122 would be against the proprietor.
Against the proprietor, 122 has been imposed.
But against the firm, the corporate entity, it's under 74.
Corporate entity, my lord, the concern only, my lord. The concern, proprietorship and the property concern are not different. That is only name, my lord. With proprietorship concern, there is no separate entity. Now,
So
once
74 is against
the
such
concern,
penalty against the proprietor.
74 is against the concern, my lord.
Proprietorship.
Property concern. And 122 is against the proprietor. Now, 127 says, my lord, that if penalty is not imposed under section 74, then 122 penalty can be imposed. If your lordship wants to look into it, my lord, I can. Yes, Pita.
127 clarifies that it has to be either, it can be either 74 or 122. Okay.
Your lordship has just seen, no?
Okay.
So once 74 has been imposed under the concern, the question of imposition of the penalty under section 122 does not arise. Now, my lord, the similar matters came up for this honorable court against the, my lord, the one issue was there that whether when the penalty was 122(1)(a) was inserted for 1/1/2021, then whether the penalty for the earlier years can be imposed or not. And this honorable court, Lord, yes, my lord,
Yes, what is this?
at para 11,
Yes.
based on the facts as before the court, and it is evident from the original prima facie does not appear to be correct insofar as the petitioner is concerned, more particularly when there is no tax demand against the registered person. That apart, penalty under section 122(1)(a) is imposed for the assessment year so and so, when it is seen clearly that section 122(1)(a) was inserted in the statute from 1/1/2021. At least for the assessment year 18-19, 19-20, 20-21 is concerned, prima facie it appears to the court that 122(1) penalty may not be applicable in the repetition of the circumstances, the respondent so and so. Now, my lord, this was the first ground, my lord, but the two other grounds that though two separate penalty cannot be imposed in the properties of concern, taking the concern separately and proprietors separately. And thirdly, even in any case, when the 74 penalty has been imposed, then as per section 127 of the Act, you'll also see section 127. Lord, I've taken.
Yes, yes. No, tell us.
Well, I may read, below. Where the proper officer.
Yes, you can read it.
Where the proper officer is of the view that a person is liable to penalty and the same is not covered by any of the proceedings under section 62, 63, 64, 73, and 74, or 74(a) or 129 of the Act, 30 of the Act, he may issue and pass an order levying the penalty after giving the opportunity of the hurt with the person. So if the matter is not covered under section 74, then 122 penalty can be imposed. Here, 174 penalty has already been imposed.
Your second and third ground are almost overlapping.
Because second ground is only on the ground that the penalty cannot be imposed at all. Because 122 penalty is on some other person. If you're lodging C 122 1A, my lord. I may just read below. It says, my lord, if any person who retains the benefit of a transaction covered under subsection 1, 2, so and so of the Act, and at whose instance such transaction is conducted, shall be liable. Because since I am the proprietor, the firm is the one and the same. How it can be at the instance of some other person?
Okay, Mr. Chetia, what do you say?
So far as the implementation of section 122 1A is concerned, to that extent, my lord, yes, my lord, this honorable court has issued notice. So for other two grounds, my lord, the petitioner, my lord, there was a clear finding, my lord, in the original order, my lord, that they are involved, my lord, in my lord, circular trading, my lord. They are taking benefits of, my lord, input tax credit fraudulently without actual transportation of goods.
No, those are on the
Lord.
allegation of fraud or marriage. But what about how do you reconcile 74 or and 122?
Yes, ma'am, we would like to file our affidavit.
Because for that allegation, the penalty has been imposed in 1674. Because of that allegations. Now, once penalty has been 74 has been imposed, 122 cannot be imposed. Because they are not two different entities.
Okay. Heard. Dr. A. Sharaf, Learned Senior Counsel, assisted by Sri A. Kaushik for the petitioner. Full stop. The petitioner is aggrieved by a demand come show cause notice.
Well, the order in original.
No, it starts with the.
Order in original.
No, it starts with the demand come notice. Demand come show cause notice dated 25/6/2025, which has culminated in an order in original dated
23/12/2025.
23/12/2025. Full stop. The Learned Senior Counsel has urged primarily three grounds in support of its challenge. Full stop. It is contended that section 122 within bracket 1 capital A bracket close of the Income Tax Act has been
of the CGST.
of the CGST has been applied, which however was inserted only on 1/1/2021, whereas the period in question is from 2018-19 to TO2 2021-22. Secondly, it is contended that penalty under section 74 has already been taken against the proprietor.
Property concern.
Against the
proprietorship concern.
Proprietorship, and therefore a further penalty could not have been imposed by invoking 122, section 122 against the proprietor. Full stop. He has also submitted that there is a clear bar under section 127 of the Act regarding such action. Full stop. Para. Let notice be issued, returnable on, yes, when? When can you get back, Mr. Chetia?
3 weeks.
It has to go immediately after the Bihu vacation, 28/20.
Let's be on 24th, Lord.
On 24, on 24. 24 April 2026. You accept on behalf of whom?
2, 3, and 4, Lord.
What about one CGC?
CGC.
CGC. Who is CGC? Mr. Roy was there.
Roy was there.
3 SS Roy.
Copy on him if you lost him.
Except for one. 3 SHT Learned Standing Council. CGST for 2, 3, and 4. Extra copies. 3
Dr. Saraf, the London Senior Counsel, placed for an interim order. Full stop. He has also placed before this court an order dated 6/2/2026, passed in WBC 625 of 2026, in which this court, while issuing notice, had passed an interim order. Full stop. Considering the above, including the grounds urged, comma, it is provided that till the returnable date, no coercive action pursuant to the order in original dated
Well, dated 23/12/2025
be taken against the petitioner.
I'm okay.
By the next date, comma, the contesting respondents are directed to file the affidavit, whereafter appropriate orders will be passed.
31 and 32 similar, same order.
Same.
Same order, only below the year which your lordship has mentioned 18/19. There's some difference below, I give it typing below. Which your
Yes.
lordship must see.
Now we can note it. Item number, next item is
Item
what?
number 30, no, it was
30?
31.
31 and 32.
30, what is 31? What is the
31 is
period?
below 18/19 to 2021.
2021, okay, 2018, 19, TO2, 20 to 21. And 32?
Next case below is 2021 and 21/22.
2021 to
21/22.
21-22. And same proprietor?
Same property below.
Oh, proprietor, okay.
And same order.
31, Harry M. Das on behalf of S committee. 32, and then again assessment.
I'm highly obliged. Sir.
Same interim notice. You take steps, Mr. Kaushik?
Yes, sir.
One is extra copies.
May it please your lordship kindly allow passover for time being.
On behalf of whom, madam?
In behalf of Ms. Tishom.
What is the matter about? Land acquisition. BTC, you're for BTC. Let her come then.
Obliged.
Pass over the matter for the time being.
Timing, why are all matters are being passed over timing? What is the matter, madam?
Sir, mandamus regarding consideration of one-time settlement proposal.
But there is a surface proceeding. How do you come to a writ court? In view of the clear direction by the Honorable Supreme Court available in the Act, writ courts are not to entertain petition. Okay, let Mr. Dubey. Yes, madam.
This is a contempt petition, lordship. The direction is at page, lordship. Page 17, lordship, paragraph 12, and thereafter we have submitted representation and then reminder also. The direction to the District Commissioner, Karimganj, lordship.
So how do you explain your delay in coming to the court?
Lordship, we have submitted the first representation on 24/6/2020.
Now, what was the direction? To take action within 6 months?
Within 6 months, lordship.
From
24/6/2024, lordship, we have submitted some title deeds also to prove the right title interest of the petitioners, lordship.
But you have come to the court after how long?
Lordship, thereafter reminder issued in the month of February, lordship.
That will not extend the period of limitation. This is contempt.
Penal action.
That I know, Lordship, and Forest Department in the meantime filed their writ appeal, Lordship. So we are waiting for the outcome of the presentations.
That'll not be an excuse.
But Lordship,
If
we
the
have,
contempt proceeding, penal action is there, you have to follow the limitation.
Lordship,
It's
but
apparently barred by time.
we have explained it in our petition that
Where
Lordship.
is the question? Where is the scope of,
Lordship, the first they assured us that we will take some time.
Madam, where is the scope of consideration of a condemnation to condone the delay? Is there any scope? Under what provision?
Lordship, there is no provision, but it was, first they assured us that we will consider your representations, we will take some time.
You were late in coming to the court.
Lordship, may kindly issue notice, Lordship, whether
Why?
they are educating on the representations or not.
This has to be issued on a prima facie satisfaction. Did you make out a case? Yours is a case clearly barred by time. The order
There
is
is a direct
31/2024.
Yes,
More
Lordship.
than 2 years have passed.
Lordship, we have filed it is on 24/11/25.
Which one?
This case, Lordship.
But still then, from to 11/2025, almost 2 years.
Reminder was issued in the month of February 2025, Lordship.
Reminder will not extend, madam, that you know. Reminder is not going to extend. Difficult. Heard,
Then
Miss
else satisfied.
R. Chaudhary, learned counsel for the petitioners who have alleged willful and deliberate disobedience of an order dated 31/2024 passed in WPC so and so. Full stop. The learned counsel has submitted that reminders have been given by the petitioners for compliance. Full stop. This court has, however, noticed that approach to this court by means of this petition has been done far beyond the period of limitation prescribed under the Contempt of Courts Act. Para. Be that as it may, that notice be issued returnable on 10th of April 2026. That steps by split post PTAD. The aspect of maintainability of this petition on the ground of delay and laches is however kept open.
Deeply updated.
56.
May I please? But additional affidavit has, I think it has tagged, my lord. Well, in that additional affidavit, we have apprised your lordship that after filing this writ petition, we have been informed by DTO that is page 28, my lord, to furnish the all particulars. Accordingly, we have furnished all the particulars except the NOC from all legal years. But I have filed the next to kin certificate. But problem is that there are children from the first wife. They are on the way. Now, vehicle was in the name of my husband. After death, there was a huge loan in the finance department. I have cleared the entire dues of the loan. And thereafter, vehicle, I have got 2 minor children. I required the vehicle. That's why it should not be continued in the name of the death person, because insurance policy also, they are declining to accept it, the death person. That's why we have applied for the transfer. Now, the embargo is that legally from the first wife, they are not giving it. And otherwise, all the particulars we have submitted.
But they may also have a claim.
Yes, I admit, madam. But the entire amount was paid by me, madam. I have annexed
That you have done at your own risk. Now, suppose without any adjudication process, who would be the owner of the vehicle now after the death of the husband? You, by paying the loan, there cannot be a better claim unless you can sort it out that the other persons do not have any objections if the vehicle is transferred to your name.
Madam, we have tried to mediate the matter.
Madam, what can be done?
Documents are required for transfer of ownership of vehicle. We have informed the petitioner also. Whenever
Are you expecting some obstruction from the children of the first wife?
No, we have tried to persuade them. They said, no, we want the vehicle. That is the problem.
this is their family problem. We can.
Then it will be difficult.
But the whole vehicle cannot be given to them because we are also legally. I have got a children. I am also legally here. That is the dispute, my lord.
No, in that case,
if they come for negotiation for any money, my lord, that could be considered, my lord.
No, it is up to you.
They are not accepting anything, my lord.
Have you made them party?
I have not made them party.
They make them party.
kindly
Make
allow
them
me.
party, make them
Then
party,
kindly allow.
make them party. Heard Sri S.C. Biswas, learned counsel for the petitioner who has also informed of filing an additional affidavit on 10/3/2026. Full stop. The matter pertains to a claim for transfer of a vehicle.
Ownership.
Transfer of ownership of a vehicle. Full stop. The vehicle was registered. The vehicle, what is the vehicle?
Siddhi Ghoshan, my lord.
No, name. What is the vehicle?
Tata Tier.
Huh?
Tata.
Tata?
And the Tata suit. My lord, page 10, kindly see.
Now, what is
Tata Tiger. Tata Tiger. Exhaust.
Tiger. The vehicle Tata, the vehicle Tata Tiger was registered in the name of the husband of the petitioner, who had passed away on 24/12/2021. Full stop. It is also the case of the petitioner that the loan pertaining to the vehicle has been repaid by the petitioner and thereafter had applied for transfer of the ownership. Full stop. However, the Transport Department has insisted of no objection from all the legal heirs. Full stop. Three, besides the learned counsel has submitted that there are certain legal heirs from the first wife of the deceased who are not willing to submit no objection. Full stop. It is however seen that the aforesaid legal heirs are not made parties in the writ petition panel. Sri Biswas, the learned counsel, at this stage prays for some time to take appropriate instructions and file IA for implement of necessary parties. Full stop. List along with the IA which may be filed. Miss MD Bora Kolden, একটা কথা বলছেন নাই কোনা Miss MD Bora learned standing counsel Transport Department is present.
57.
My pleasure.
Yes, what is this, Madam Das?
Petitioner before this honorable court is a property farm, my lord.
Oh, Panchatantra.
Yes, my lord.
Now you know what is Panchatantra.
Yes, my lord. Vishnu Sharma wrote Panchatantra.
Now you know Vishnu Sharma has written. Okay, what is it?
My lord, last occasion instruction was sought.
You are aggrieved by GST cancellation.
Actually,
What are the facts, madam?
my lord, petitioner provide.
You have a business.
My lord.
Of what?
Rental vehicle to different department, my lord.
Okay, you let out rent vehicles. Okay, then you had a GST registration.
Yes, my lord, in 2017. I have filed.
2017. Yes. After
Due to stagnant of my business, I have not filed, my lord, my GST return. I have last filed for 2023, my lord.
4/11/23 last return filed.
I have filed. And in 13/11/2020, without stating any reason, my lord, they have suspended my GST registration, my lord.
13/11/23. GST suspended. What are the reasons?
My lord,
Because 4/11/23 you had filed the last returns.
yes, my lord, online portal allow me to file only till 4/11/2023.
How often are you required to file the returns? Every year or what? Every quarter?
My lord,
Not every 3 months.
Every quarter. Every quarter. What are the reasons? Prescribed, see, last returns, we have just narrated that on 4/11/2023, you had filed the last returns.
My lord.
So immediately thereafter on 13/11/2023, GST has been suspended. Why?
My lord, they have not stated any reason.
Since my lord, they have not filed return consecutively.
No, but, she says that 4/11/2023 returns were filed.
My lord, thereafter. My lord, ultimately, lordship, purpose notice was issued page 29 in HLB, 13/11/23.
29.
Page 29. And whereas on the basis of information which has come to my notice, it appears that your rescission is likely to be cancelled for the following reason. Returns filed by you under section 39 of the CBS so observation. Failure to furnish return for a continuous period of 6 months. So therefore, my lord, so was issued, no reply was filed. Thereafter, my lord, this cancellation order was passed, my lord. Page
Cancellation is page?
30.
It's already been cancelled.
Not. So against this, they had approached Chief Honorable Court.
24.
On the last occasion, my lord, I was directed.
But
to-
Mr. Chetia, if what has been projected by Madam is that the last returns were filed on 4/11/2023. How could this 13/11/2023, with an observation that failure to furnish returns for a continuous period of 6 months?
But yes, then that extent, my lord, I have to take instruction. My lord. Otherwise, my lord, the notice itself, SOCO's notice itself clearly stated that my lord, return was not furnished for last week.
6 months, that is what is concerning. Because 4/11, there is also some document. Where is the document, Madam? 4/11 you have filed?
They have not done it.
From where do you make this averment? 4/11 you had filed. You said that they have also acknowledged.
It's a reply from portal, my lord, because I have filed through online, my lord. As allowed by the GST portal, allowed me till 4/11/2020.
They have annexed D, my lord. Page 31.
Yes.
It shows the date, my lord.
Where is the date?
What's the date of here?
4/11, yes, you're correct.
4/11/2020.
Yes.
In any case, my lord, in series of matters, my lord, this court has allowed for restoration of registration.
Yes, we have passed.
Conditions.
Yes.
Where is it gone?
Passport.
You have got the instructions. It can be passed.
Lordship, not, my lord, the but department has
No, that was the purpose of not disposing this matter on the first date.
not.
No, this court has also passed orders. Where is that?
My lord, I have already enclosed one order. This is covered matter, my lord.
In this petition? Which page?
Page 36, annexed D.
This is a new one is
30?
6, my lord.
Not 36. 36 is something.
36 is
39.
my lord 30 now. Paragraph number 6.
39. What about orders by this court? I think we had passed many orders. GST can say Mr. Misra's
Lordship.
and Mr. Gupta's
Yes.
case. Do you have those copies? It will be easier for us to follow. Madam, do you have a copy of the order passed by this court? At 2 o'clock, come, try to come, okay? We'll dispose this of. And take out the order and also make the necessary factual correction, both of you.
Mine.
And we'll come at 2, we'll have it at 2 o'clock, okay? This you can have. You can ask Mr. Mishra, R.S. Mishra. I think he has done a number of matters. Okay, next.
58.
Okay. 58,
My
Mr. Borguya.
lord. Yeah, my lord, petitioner name appeared in the Jamabandi, my lord, but even then, my lord, a notice was issued at page 27, my lord, for eviction. Thereafter, my lord, we have already replied.
Now, your issued notice for?
Notice for the eviction, my lord. 165 for land revenue regulations, so and so, whereas on the upon preliminary investigation, it was established that illegally possessing and it was the violation of so and so.
165.
My lord.
Tribal belt.
My lord. Prior to that, my lord, we have already purchased, my lord. My name has already been mutated.
Now, let us see the purchase document.
Purchase document, my lord. The
Jamabandi
Jamabandi part
name
is
is
there.
not nothing to do. It is only a record of rights. We are more interested how you procured land in a tribal belt and block. If you are procured prior to
Prior to-
1951, matter would be different. If you have procured thereafter, how have you procured? Your age is only 38.
My lord, my father-in-law, my lord.
Father-in-law.
Has sold to his daughter's husband.
Let us see the deed.
Deed I do not have.
Then it will be difficult.
My lord, then we'll file.
Your
my-
father-in-law will not be able to sell in a tribal belt and block. Then permission will not be granted. That is why you do not have the
It
deed.
seems that, my lord, from Jamabandi, my lord.
See, insertion in the Jamabandi is not, will not, as you know, will not
My lord.
vest any right upon you. It's only a record. Right has to flow from a title. The title has to flow from a deed. Either it can be a sale deed or a give deed or
Yes,
inheritance.
yes. My lord, then I'll file additional affidavit along with the, my lord, the Khazna receipt we have given, my lord.
Khalsa may not be. We want that how the title has flowed to you. We want
Lordship.
more interest on J. Sri J.I. Borbhuya, learned counsel for the petitioner who has put to challenge and a notice dated 31/12/2025 issued by the Circle Officer Morigaon. Full stop. No. Whereby the petitioner has been proposed to be evicted from the land said to be under his possession. Full stop. The notice has mentioned section, it's not section actually, regulation 165 within bracket 1, 2 of the Assam Land and Regulation, Assam Land and Revenue Regulation 1886. Full stop. Para. Both Sri S.S. Roy, the London State Council, and Ms. P.R. Mohanto, London Standing Council Revenue, have contended that the aforesaid provision is a part of Chapter 10 of the regulations, which pertains to creation of tribal belt and blocks, so as to give adequate protection to the backward classes. Full stop. They have also submitted that no documents have been enclosed to the writ petition to show as to how the land was procured by the petitioner. Full stop. Para. At this stage, Sri Borbhuya, the learned counsel, prays for me and is granted 3 weeks' time to file additional affidavit along with such documents.
Lord.
Should we fix a date?
Well,
List on. On the, wait a minute. Can you file it within 2 weeks?
2 weeks, my lord, we can.
You can, on 25th
25th of
March. Yes,
My lord, on the last occasion, my last.
35G.
Yes, 35G. Actually, we have filed the appeal.
35G you have filed.
No, because sister tribunal we have filed. But actually tribunal uphold the order of the commissioner appeal on the ground of limitation and dispose the case is not maintainable. So actually in this case, whenever the appellate tribunal has disposed the petition on the ground of limitation, at this point of moment of time, doctrine of merger is not applicable because whenever any appeal is dismissed on the ground of limitation, so that is not cannot be merged with the.
Kindly show us a case law.
Yes, my lord. That is second law by this Honorable Supreme Court.
I think this is now different context altogether.
So,
It is on a different context altogether. This was, see the penultimate paragraph at paragraph 12.
yeah,
The question now that falls for a consideration and decision is whether the tribunal was justified in not considering the case of the assessee on merits.
because commercial clause-
On merits.
Yeah.
Assessee's stand before the tribunal and before this court is that the orders passed by the adjudicating authority would merge with the orders passed by the first appellate authority, and the tribunal ought to have considered the appeal filed by the assessee on merits also. In our opinion, the same cannot be accepted in view of the plethora of decisions of this court, wherein this court has categorically observed that if for any reason an appeal is dismissed on the ground of limitation and not on merits, that order would not merge with the orders passed by the first appellate court.
Yes, sir. That is.
In that view of the matter, we are of the opinion that the High Court was justified in rejecting the request made by the assessee for directing the revenue
Yes. In this, I am
to
not.
state the case and also the question of law for its consideration decision. Mr. Kyle would like to.
Here, what happened, initially they approached this honorable court. This honorable court find that there is an alternative remedy available. They preferred first appeal, second appeal. Lordship ultimately CSET decided their appeal on.
Limitation. Dismissed by petition or limitation.
Against that order under section 35G, appeal lies to the High Court.
What is the difficulty in coming to the High Court?
No, here is the honorable.
Same
tribunal
court
not discuss the law points is here. It is not disputed. And actually, my lord, in another Supreme Court has also 2020 stated.
We'll have this we'll issue a short notice.
Yes.
We'd like to have your response. Okay, on the availability of 35G.
Yes.
And why this decision may not be applicable. Because if the High Court at one point of time had directed you or remitted you for taking the recourse under the Act, which you have done, gone to the extent of the second appeal before desisted.
Yes.
Now 35G is there. How can you again jump tracks and come to the writ court?
Actually, sir, certain law has been settled at Supreme Court. Whenever tribunal is a larger than decision of the Karnataka High Court in this matter, the same situation is arise. The same situation arise. When the larger decision of the Karnataka High Court is stated that it is not possible to restore back again to the merit of the case, but should be recourt has the jurisdiction dispose the case.
But that process has not attained finality. The process will attain finality when you exhaust your remedy under 35G.
But
And
here-
35G, the forum is the High Court.
Yes, sir.
But here at the larger bench case.
Huh?
Page 140.
140.
Yes, sir.
What is 140, Mr. Sahu?
Briefing them to the.
Initially, we approached this honorable court. Honorable court stated that since there is a alternative remedy, this should be availed.
What is the division bench?
Yes, sir. Thereafter they
So
preferred.
I prefer the appeal before the appeal commission appeal, and thereafter the assistant. So at this stage, there is no way to interfere with the order with any other forum, because the order itself is a invalid.
Heard. Speak. As Sahu, learned counsel for the petitioner. Full stop. The petitioner has challenged an order dated. What is the date of the order? Order in original dated 9/11. No.
Yes.
What is the original order dated?
Or is it
9/11, 2011.
11?
11.
Yes, sir. That has already been taken care by this honorable court. Thereafter they preferred appeal against that order. Ultimately, CSET passed order.
9/11/2011, whereby demands were made after culmination of a proceeding initiated wide a show cause notice dated
18 March.
18/3/2011. Full stop. It, however, transpires that the said order was initially put to challenge before this court, and a division bench of this court, wide order dated 14/2/2013, has dismissed the same by directing, by observing that the order was appealable in nature. Full stop. The learned counsel has submitted that though an appeal was preferred, the same was dismissed, whereafter a second appeal was preferred before the system. Full stop. However, the second appeal was dismissed on the grounds of limitation, and therefore he contends that there is no adjudication by the said appellate authority on the merits of the case, and has also tried to invoke the doctrine of merger, and has also submitted that the doctrine of merger would not be applicable in such a case. Para. On the other hand, Sri S.C. Kyle, learned senior standing counsel, CGST, has contended that once a division bench of this court, wide order dated 14/2/2023, had dismissed the petition, but the writ petition by observing that an appellate forum is there, which the petitioner had accordingly availed, without filing an appeal under section 35G of the Act, the writ petition would not be maintainable. Puts the parent. Let notice be issued, returnable on. How soon can you file the affidavit, Mr. Kyle?
This is only.
Okay, but you need to take instructions. We like to hear you on this. On when
The first week of April.
first week of April, on can we have it on on 1st of April or 2nd of April? 2nd April?
Second.
2nd April, 2nd of April. You accept on behalf of all the Kyle accepts notice on behalf of all the respondents, their extra copies be served. On the merger aspect, kindly take instructions and also look into the aspect that dismissal on the grounds of limitation would also amount to, there are decisions,
Yes.
amount to dismissal on merits.
Yes.
Okay.
Much. Item 23.
And I think in Radhesam it has been said, because it was said in the context of revision or second appeal in case a limitation on the ground of
Yes, sir.
limitation in the first appellate court. The law was changed, Radhesam, I think it was. Item number?
Might be the lot.
33, time being, okay, what is it?
But here we are, we have submitted a representation of one
What
time.
is that surfacey proceeding?
Surfacey, we have
There
already
is a
filed.
clear direction of the Supreme Court, reiterated, do not entertain.
But so far as surfacey is concerned, if your lordship would see para 25, I have, there is a notice they have been issued to me, my lord, on 5/2, which I have challenged before DRT under
Okay.
the surfacey.
Hmm.
But this is as regard, my lord, consideration of my OTS proposal vis-a-vis RBI guidelines. My lord, they have a, my lord, I have a right to consider, my lord, whether they will do it or not, my lord, that's on what manner that would not be reviewable.
Is Baroda Bank represented by any counsel?
No, my lord, notice has to go, my lord. Because they don't have, they have panel counsel.
So you have the grave doubts on the maintainability.
Well, I'll satisfy your lordship on this.
Sri R. Dubey, learned counsel for the petitioner who's primarily aggrieved by non-consideration of his application or of his proposal submitted on 23/1/2026 for one-time settlement, full stop. I want a settlement by the respondent number 1 bank. It is submitted that there are clear guidelines by the Reserve Bank of India in the form of circulars, as per which there has to be a due consideration. Full stop. This court has, however, noticed that a surface proceeding, that the present action is connected to a surface proceeding. Full stop. Be that as it may, that notice be issued returnable on on 1st of April. Can you serve by 1st of April?
Yes, my lord, may also permit me Dasti, my lord.
1st of April. Let steps be taken for service of notice upon the respondents by speed post with AD. Whom will, no, 3 is district commissioner.
Yes, my lord.
1, 2, 1, 2, no, 3, no, 23, but 3 by so and so, extra copies. 1, 2, and 4 by speed post with AD. You served Dusty on whom?
My lord, 1, 2, and 4.
4 is Reserve Bank of, okay. You can
They also have a panel council, my lord. I have requested
Okay,
them. They say they only after notice.
Dusty for 1, 2, and 4, huh? So you got to kind of look at it. You have to file an affidavit before that.
Yes, yes, we will.
The maintainability of this writ petition is, however, kept open.
My lord.
Item 60.
May I please your lordship? Lordship, this is the second round of litigation, my lord.
Yes.
The petitioners, my lord, they along with some other persons, my lord, they have 26 bigha, 4 kotha and 15 lesas of plot, my lord. And their land were acquired, my lord, on 4/7/2008. But my lord, thereafter, nothing has been paid at that time, my lord. Thereafter, on 2016, one writ petition was filed by the petitioners, my lord. Thereafter, my lord, Honorable Court on 18/9/2017 passed an order, my lord. Lordship, may kindly come to page number 36. And operative portion is 42, my lord. Operative person is 42, my lord. Operative page is. Honorable Court, my lord, directed, my lord, to pay the amounts, my lord, as per 2013 Act, my lord.
Yes.
Thereafter, my lord, the government, my lord, didn't pay anything, my lord. Thereafter, contempt petition was filed on 2018, my lord. Thereafter, my lord, lordship may kindly appreciate that government has paid some amount, my lord. Lordship, before that, my lordship may kindly come to page number 53 for a moment, my lord.
Yes.
Page number 53, my lord, the amount which was approved was 4,84,48,354. Now they have paid, my lord, only 4,93,50,100 and 1,100, my lord. Why they have deducted, my lord? Nothing has been reflected.
No, but payment is more. You said 4 crore 93 lakhs they have paid. But
yes.
It was 4 crore 84.
4 crore 84 was sanctioned, my lord.
Now you have, you have been paid more.
No, they have, sorry, released, my lord, 4 crore 58 lakhs. 4 crore 58 lakhs 858,662.
Entire amount not released.
Not released, my lord. Now, lordship may kindly see. My grievance is that, my lord, when they have prepared the award, my lord, the section 30, subsection 3 and section 80 totally not followed, my lord. Totally not given, my lord. May I, lordship may kindly have the.
I will issue notice at this stage.
My lord, my lord.
Third free as Dr. Learned Counsel for the petitioners. Full stop. As per the facts projected, comma, the land of the petitioners were acquired and as no compensation was paid, comma, the petitioners had instituted WPC so and so page 36 available, huh? Full stop. The said writ petition was disposed of by this court wide order dated 18/9/2017 by directing payment of compensation as per the right to fair compensation 2013 Act. Full stop. However, in spite of such direction, no payment was made
resulting in the petitioner instituting a contempt proceeding, a contempt petition, full stop. After filing of the contempt petition, some payments were made, full stop, in this regard, comma. The learned counsel has drawn the attention of this court to a communication dated 28/7/2021
Yes, ma'am.
issued by the department, whereby as an estimate of rupees 4,84,48,354 was sanctioned. It was not sanctioned.
Approved.
Was approved.
Yes.
Full stop. The grievance of the petitioner is that while making the actual payment, there has been a substantial reduction.
52, page 52.
Reduction. The petitioner has also alleged violation of section 30 within bracket 3 and 80 of the Act of 2013. Para? That notice be issued, returnable on on 6th on 1st of April 2026. Who will take notice? Yes, who is one, madam, Mr. Doctor?
My lord.
Nothing. No department.
My lord, I'll file, I have to.
What is this? What is 1, 2? Who's 2? You will, madam, for 2. And Goswami for 1, you take for 1 also. You 1, 1, 3, and 4. Then your name, madam, for RM Das. For 2, 5, 2, 5, and 6.
Finance department is 7.
Commissioner Finance 7, 7, 7, H. Barua for 7, and Revenue for 8. So, Bhogisana. So, Bhogisana. Extra copies. Okay. Yes.
I love it.
Appellate.
Yes.
You can make the corrections and place it before a court master. Heard Miss M. Das, learned counsel for the petitioner, as well as Sri S. Chotia, standing counsel, CGST. Okay, can you make the corrections factual? Both of you, huh? Verify and give it to court master. Same order, dispose of.
Item 30.
Have you made the corrections or you're making it now?
What you will do it?
Okay, okay. Item number
13, my lord. May,
30. Yes. What is it?
yeah, yes, my lord, the petitioner's patta land has been acquired by the respondent authority. Although a Jirat value, lump sum Jirat value as reflected in page 27 has been paid to the petitioner, but the determination which is required under 26 of the Right to Fair Compensation Act 2013 has not been followed yet. Lordship, petitioner made different follow-ups with the authorities, but till date. So may I pray at this stage, let notice be issued.
Acquisition was under which act? Acquisition was under which act?
That was
You are still in possession of the land.
Part of land, because max other part has been acquired, little portion and
Yes, what do you say?
Payment already been.
Payment has been made. She says that only the Girard value has been paid, not the acquisition amount.
Lordship representation file Lordship 18/2020. Our payment has met on in the year May 2008 and 20, before 2020. Long back Lordship. So many years.
Yes, his correct representation is of 2020.
yes, Lordship.
You have come to the court after 6 years. Why?
No, follow-ups have been made by the petitioner from time to time, and
Where, madam?
verbal assurance has been given by the.
No, the last representation is page 30, 2020. Thereafter, what follow-up? Where is the follow-up?
Verbal follow-ups with the.
Where have you made this?
As instructed.
Where have you made this statement?
Accepted the.
Para 18 Lordship, the petitioner stated he has made several verbal communications with the
Verbal communication will extend
authorities, but no fruitful result has come.
There's a lectures on your part, madam. How heard? I heard Miss Soom. This is item number
30 Lordship.
30. Heard Miss T. Soom, learned counsel for the petitioner who is aggrieved by non-payment of compensation amount for acquisition of land. It is provided that it is the case of the petitioner that land was acquired for construction works, and though the Girard amount has been paid, the acquisition compensation has not been paid. Para? What is your name?
PC Musari.
BC.
Musari.
Sri BC Musari, Learned Standing Council, BTC, has however raised the objection on the ground of delay in approaching this court. Full stop. He has also submitted that the compensation amount has been paid. Para? That notice is issued, returnable on 9th of April 2026. Three and Goswami Learned State Council for 1, 4 and 5, and Musari, BC Musari for 2 and 3. Extra copies.
Versus 5 also.
I think circle officer will take. You are for 1 and 4. 1 and 4, then Musari for 2, 3 and 5. Huh? Extra copy. Let's see.
Obliged.
Yes, serve furnish extra copies.
61.
May it please your lordship.
Yes, madam.
Lordship, in this matter, without prior so cause notice, DRC 01 is issued. And lordship, raising demand. And subsequently order was passed confirming that demand.
Without show cause.
Without so cause notice, lordship.
Similar matters are fixed on Friday, madam.
This Friday, day after tomorrow. Are you the counsel in those matters, madam?
Lordship?
Are you the counsel in those matters?
Yes, lordship.
In few of the matters, you are the counsel. So we'll have it day after tomorrow.
Obliged.
Okay. Heard your B. Sharma. B. Sharma.
B. Sharma.
Heard Ms. B. Sharma, learned counsel for the petitioner, who is aggrieved by a DRC 01 proceeding, which culminated in an order dated 29/9/2023 of confirmation of demand.
Yes.
Full stop. It is submitted that no show cause notice was issued. Full stop. Para. Sri H. Barua, learned Standing Council, Finance within bracket Taxation has however informed that similar matters are fixed for consideration on 13th, correct?
Yes, Lord.
Comma, one of those being WPC
1122.
1122 of 2026. Puts the para, list for consideration. And accordingly list for consideration on 13, so and so along with WPC so and so.
Deeply obliged, Lord.
62. Maybe the lordship.
Yes.
Lordship, this matter lordship relates to eviction lordship. And here I am only for one lordship. I am the part holder lordship. And I have challenged on the ground lordship that my forefathers are lordship residing their lordship since lordship 1923 recorded their lordship. So lordship till that lordship our forefathers and thereafter lordship grandparents lordship they are also their lordship. And subsequently my name lordship I have purchased this Patta land. That is in the 2007. And my name is also included in the eviction notice lordship.
You have purchased Patta land.
Patta land lordship.
Where is the deed?
Yes, lordship. So it is their lordship. Page 19. Yes, lordship. Yes, page 19 lordship. Lordship, government has duly after due verification lordship this is done lordship. So lordship, my land at least lordship should not be in the eviction list lordship.
It starts from page 19, my lord, and the schedule is at page, my lord, 25.
Doc number 343.
Yes, number 3.
Patta 58.
Yes, lordship.
Now this lordship comes to, my lord, page 28. Page 28 is the.
What item number?
62, I think.
Your Hawk,
Yes, lordship, yes.
Mr. Hawk, how could you purchase land in a tribal belt and block
Lordship,
in 2007?
Yes, lordship. That is the question, lordship. The government, that is when the lordship sale procedure is their lordship, then lordship, the government lordship, they have to physically verify the land lordship, physically verify our status lordship. The Mondol or Circle Officer lordship, they own the field lordship. After all,
So this is apparently an erroneous process. If this is the list of the expressions we can use. We can use many other expressions. How can land which is admittedly in tribal belt and block be sold to a non-tribal?
No, lordship, there is some reason.
There is a bar
under
chapter 10.
Lordship, because where forefathers is their lordship, where their lordship.
No,
only I am not outsider, that I am suddenly.
Mr. Hawk, you trace your right to this sale deed. Your forefathers are there, not in this plot of land. We are concerned with this plot of land, which is the subject matter of this sale deed.
Yes.
Measuring 3 kathas.
Yes, lordship.
Correct?
Yes, yes.
So in 2007, could you have purchased a sale deed, made a purchase of land, which is admittedly in tribal belt and blocks?
Lordship, if that could not, then government should have raised objection at that time, lordship.
Yes, Mr.
Because,
Borpujari.
Why then they have given this, and they also own the field, lordship.
See, his submission so far as forefathers are concerned,
Yes.
that we are not too much concerned at this moment because this 3 kathas is covered by this sale deed.
And there is no evidence, my lord, appended to the petition to show that, my lord, that these forefathers were there.
No, we are not on the forefathers aspect.
That is their lordship.
We are on the aspect of purchase of land. Let us forget the forefathers aspect.
Then also.
He accrues right by means of this sale deed. In 2007, this sale deed has not been put to challenge.
Yes, lordship, right there.
That sale deed is not put to challenge. Now, this sale deed is, of course, my lord, a private document. This is not a public document. It is my lord, transferring of right interest say between my lord, the buyer and seller. Now, lordship, for a moment, lordship comes to my lord, page 28. Page 28 is the Jamabondi.
Yes.
Jamabondi also, my lord. This is the vernacular, my lord. Jamabondi, page 28, my lord. That it is Patta number 58.
Yes.
Page 28, my lord.
Yes.
On the second column from the left hand side, lordship will see,
Yes.
my lord, it is 58.
Hmm.
Then on the fourth column, lordship will find dark number 343.
Yes.
And then if lordship turns to the next page, page 29. Page 29, my lord, in the third column at serial number 28.
Yes.
Nurjahan Begum.
Yes.
Nurjahan Begum is the petitioner out here.
Hmm.
Then lordship will kindly see, my lord, the impugned eviction notices. Then lordship will find at page 57. Now, here, my lord, everything was done. Here, everything has taken place. It is just like, my lord, the yesterday's matter which.
No, yesterday's matter, they did not have any document.
Yes, yes.
It was based on some
Only
power of
attorney.
attorneys.
Yes.
There was no transfer as such. Now the title has flowed to him.
Yes, now this send deed is the only distinguishing factor with that of the yesterday's matter, my lord. That much I can supply.
Hmm.
Let us
You
find-
have to take instructions on this particular sale deed.
Yes,
Today is for the first date, but he would be entitled to some protection.
Yes, lordship.
Because see, the sale deed prima facie does not appear to be validly done because it could not have been executed in an area which is protected by chapter 10.
what is more disturbing is that, my lord, subsequent to the sale deed, execution of the sale deed, her name has also been mutated.
Mutated.
And recorded in the record of rights. So she becomes a patta holder. Rightly,
Yes, sir,
wrongly,
yes,
whatever- Rightly, wrongly, whatever it is.
And that is what you need to take instructions about. And if you think that the sale deed, the execution and of the sale deed was also accentuated by many other factors, you take appropriate action.
Absolutely.
We'll be very strict on this.
Absolutely. If lordship may be pleased to fix a short date of notice.
Yes,
And the affidavit itself.
Yes, heard Sri S. Hawk, learned counsel for the petitioner who has put to challenge an eviction notice dated 27/2/2026 issued by the circle officer,
Yes, lordship.
Azara,
Revenue, sir.
Azara Revenue. He's not respond number 6, he's respond number 5. You have written respond number 6, respond number 5. The circle officer, Azara Revenue Circle. In the synopsis, you have written 6.
Yes.
Yes,
Sorry.
The basic contention of the petitioner is that she had purchased the land in question by a registered sale deed, which has been registered sale deed dated December 2007, which has been enclosed. Full stop. He has also submitted that subsequent to such purchase, the name of the petitioner has been recorded in the Jamabandi. Full stop. Para. 3. R. Borpujari, Land Standing Council Revenue, has submitted that prima facie the land in question is a part of the tribal belt and blocks and protected under chapter 10 of the Assam Land and Revenue Regulation 1886. Full stop. He has also submitted that the vendor, both the vendor and the vendee of the sale deed are not tribal people, and therefore such deed of sale appears to have been executed without considering the relevant factors. Full stop. Be that as it may, let notice be issued. Let appropriate instructions be obtained on this, in this regard. Para. Let notice be issued, returnable on. And can we have it on 30th of?
Yes, 30th of March. Yes, my lord.
30th of March?
30th of March, and prior to that, my lord, we'll be filing our affidavit.
30th of March. 3. Borpujari, the Land Standing Council Revenue for 1.
My colleague will be appearing.
One and only one, I think.
Only one.
And Mr. N. Goswami for State Council for 2, 3, 4, 5, and 6 extra copies.
Yes.
Para 3. Hawk, the Learned Council prays for an interim order, which has been resisted by the Learned Council for the respondents. Full stop. However, taking into consideration the registered sale deed of the year 2007, it is provided that till the returnable date, no coercive action for eviction of the petitioner be taken. Full stop. It is made clear that this interim order pertains only to the petitioner, as the impugned order also encompasses other persons. Also encompasses, also includes.
Extra copies by tomorrow.
Extra copy কৈছা ওপৰত না? Yes, Mr. Ahmed.
I have a very good bad case, my lord. It is covered exactly in the yesterday's case. But however, in my case, you also kindly see the notice, you will also kindly see the notice, page 111. A notice has a whole pattern number, DAG number has been mentioned. No specific boundary, no specific DAG number, no quantity of land has been mentioned. And some of the petitioners even did not receive any notice. However, they appeared, they filed their reply to the authorities, and a hearing was taken place on 15/10/2025. And hearing was started from 15/10/2025 to 22/10/2025. Then the outcome of the hearing, the order, whatsoever order passed, has not been communicated to us. This is the main ground. So instead of doing so, my lord, they directly again issued a notice, eviction notice, asking us to vacate the land within 15 days.
What is this order then? The outcome?
Outcome?
Directing.
No order has been communicated to us.
This order?
No order, that order is now.
This is not an outcome of the order of the proceeding.
Outcome of that.
You need many orders to be passed. Hearing is over, one order. Orders being considered, one order.
No
new grounds, Mr. Ahmed.
yes,
We have considered everything yesterday.
And
If you make out some other grounds,
Other
Mr.
grounds.
Hawk had made out other ground.
other grounds
He was
is fine.
entitled to some relief. That's a
Just-
different matter.
No, yes, madam.
You make out any other ground. Yesterday we have
Yes, yes.
given our consideration.
Yes, madam. Just now I placed for judgment in this regard, madam.
Regarding?
Regarding the eviction, final decision taken, and thereafter, after taking decision,
See, these matters are particularly covered by a specific order of the Honorable Supreme Court after PL 78.
Right.
We cannot move here and there. We will go specific orders of the Supreme Court passed in this PIL, in the order passed by a division bench in the PIL.
correct, madam.
The other decisions will not be, is not required to be considered. There's a specific decision of the Honorable Supreme Court on this issue. On the PIL which was filed for making the tribal belt and blocks of that area encroachment free.
Now, in that PIL, the Honorable Supreme Court also passed that order, madam.
We have referred to this order.
That order.
We have referred to this order.
What
We have
is
referred to we have referred, considered, we have reflected this order in our judgment.
No, but the final outcome, my lord, the petitioners get another opportunity to file an appeal. That has been not.
We have declined it. Sorry, same order.
Some order, some time can be
No,
granted.
we have not granted any time. Dismissed. Yes, yesterday's order will follow.
Yesterday's letter is WPC 1451.
I think it's not been, has it been uploaded?
That is WPC 1451 of 2026.
Oh.
Khan Muhammad Ali and others.
Yes, yesterday I had considered.
Yes, yes.
It will be uploaded just immediately after we rise.
Hello.
So. Item 34.
এইটো দুটা এক্সট্ৰা হেৰি দিবা হা এইখিনি এইটো সোমাই দিব লাগিব কালিটো কোনে মাৰিছিলে পুনম ৰেডি কৰিব লাগিব এইটো আপলোড কৰি দিব লাগিব এইখিনি আমাক সোমাই দিব লাগিব হা insert. Yes, yes,
May it please your lordship. In this matter, your lordships will kindly go into your lordship's order, wherein this matter, in this case, your lordship, the petitioner, an eviction notice was passed in 2018, it has already spent its force. And
Yes.
secondly, my case was that I have already applied for settlement, wherein my next door neighbor has already been settled, I am not done.
Yes,
And on
Mr.
this
Nayak.
day, your lordship
Yes,
was
we remember, Mr.
Yeah.
Nayak.
He was supposed to take the instruction whether it can be disposed of, because your lordship was eager to dispose it of on that. Nine, put good, right? Nine now. Now, put.
Instruction, I have received the name of denial.
Gopula, this is the one.
Whether this was after your lordship's order, that is, I don't know.
Yes, it's after the order.
Yes.
It's 10/3/2026. We passed the order on 22/22.
Exactly.
Which references of the director to convey the joint survey
Yes,
received from the joint director. So and so, so and so.
Copy it off. Copy it off.
The original maps are missing.
Yes.
And they have made an request that the aforementioned village is currently non-cadastral. The survey of the village is presently in progress. Settlement of land in favor of the applicant may be considered upon the completion of the survey, subject to fulfillment of all prescribed criteria and eligibility.
So they are not averse to it. Only thing is that, yes, there was, I have already stated, because no demarcation in that land. About 200, I think he has also mentioned about 900 bighas of land are there in total.
Okay,
So-
heard 3 Y.S. Mannan, learned counsel for the petitioner. Full stop. Miss G. Hazarika, learned standing counsel revenue, has placed before this court certain written instructions as per which, comma, due to non-availability, as per which, comma, the survey of the village is presently in progress and the area is non-cadastral, full stop. A request has accordingly been made that it has also been stated that after completion of the survey, the case of the applicant may be considered subject to fulfillment of all prescribed criteria and eligibility requirements. Full stop. Para? We can close it then,
Yes, your lordship, on the basis of that.
in view of the
And,
aforesaid
in fact, your
submission.
lordship will kindly
This court,
interfere with
this
the.
court is of the view that that the authorities are not proceeding with the notice dated 29/10/2018 for eviction. Full stop. This court has also taken into consideration the aspect that neighboring land has already been settled, which was also the subject matter of another writ petition.
No, that has been disposed of.
And,
They have
writ petition
withdrawn.
and disposed of. Para? In view of the said submission, comma, the present writ petition is disposed of by directing consideration of the case for petitioner for settlement of the land after completion of the survey, subject to fulfillment of the prescribed criteria and eligibility.
With regard to that eviction notice.
Eviction, we have already mentioned that they are not proceeding.
No, if
Oh, yes.
if they after this order so it may be have lapsed, lordship can say that one line, that will help. Then they can go again, that is a different aspect, but
If it is made clear that if the application of the petitioner for settlement is unable to be considered for valid reasons, comma, the authorities may take appropriate action for carrying out eviction. Only thereafter. Only thereafter.
against me.
No, only thereafter.
But
Settlement-
that is like giving them a handle.
No, now, how can we? Now,
No, I'm saying.
unless we cite grounds for setting aside, see, we
No,
have
I'm
taken.
not, because they have already, it was a delay, then latter part may not be.
Last part, don't forget. Last but not least. Okay, next.
Yes. Obliged.
Move the file over.
Item 35.
That's it for-
In this matter, I'm appealing as a legal aid counsel. On the last occasion, direction was given to the credit counsel for other sides. Your lordship has the last order, 3rd of February 26. And paragraph, page 4 of that order.
Paragraph,
Page 4,
page 4,
page 4, in
Yes.
order to consider, may I,
page 3,
in page 4 of that order.
in order to consider.
Yes, may I read? In order to consider the claim made by the petitioner, at this stage, it is necessary to understand whether the proceedings before the National Commission of Scheduled Castes have finally concluded or the matter is still pending. Accordingly, this information will be placed before the court by the learned DSDI. In respect of the police cases pending, more particularly dispute PS case number so and so being GRK so and dispute PS case so and so filed by the petitioner, and the status of the investigation thereon be also placed before the court by Mr. N. Das, the State Counsel. The status will indicate whether the charge sheet or the final report, as the case may be, have been filed by the investigating authority. When a standing counsel for the Social Justice Department will advise the court as to the methods and the procedure for working out the compensation as recommended by the National Commission for Scheduled Castes and also advise the court thereon. And some affidavit should be forthcoming on this. We should be quite as to that.
Should be so far as the information required from the responding number 7 is concerned.
Just a minute. Yes, what is it?
So far as the information to be given to me, the lordship will come to page 140
148.
on this. The relevant part is at page 149.
Yes.
These are the minor of the hearing. So whether it has been concluded or not. Now, lordship, my instruction is not since this case is pending, so it has been kept open as of now.
There will be neither here nor there.
Absolutely.
Because of this case pending, that is not, and we want the completion of that case.
And there was a direction for compensation, how to complete and run that.
We can clarify that pendency of this case shall not be a bar for completion of that, so that we know where we stand
Got
then, okay?
And one part will be some police cases were there.
What investigation?
Yes, what about the state council regarding police case? Mr. Roy? Where is 9/9/2022?
148.
148.
148.
Which you have just read.
Yes. Lordship, you can see paragraph 3 of the
They can go back.
page 140.
The compensation will be given by whom? Hmm? By the state. Under what provision? This body has only recommended the compensation.
It's for the state to determine.
Determine and pay also. Under what provision?
That was given under that order, the last order, my lord. The standing counsel for the social justice department will apprise the court as the methods and the procedure for working out the compensation recommended by the commission, my lord.
Yes, who is for social welfare?
No, it was RN. RN Das is representing.
How do you determine a compensation in case there is a recommendation by this body? No, there are two aspects. Now this is a recommendation for payment of compensation of huge loss incurred. Now the loss has to be determined, number one. Secondly, who will pay the compensation? And number three, whether this loss would be in the nature of damage also, where it is unliquidated. Suppose mental harassment, it cannot be assessed in quantitative or objective terms. It is see the status, see the nature of the case, then you come to a particular figure. It is not on some calculation. So how do you arrive at this?
Let's come to page 160.
160. Yes. This is a schedule.
Yes.
You know, the Gazette.
Schedule ka second. Here was the case where it is alleged that a frivolous complaint was filed and there was an inquiry. Thank you, sir. Yes, sir.
As per the last order, madam, you have to apprise this court.
Okay, sir. Bonafide policy. Oh, you have to go see. It will go see. India to Hospital Department.
Mr. Bonik not made a party in this proceeding.
No, we had filed it in IMA, whereby it was allowed Ministry of Social Justice, Empowerment, Government of India, Department of Social Justice.
No, that will be Government of India.
National
No.
Commission for Scheduled Castes.
Who will pay, the state government or the central government?
There will be two parts. One would be by the Deputy Commissioner to be paid under the Act, and the other to be by the Department of Social Justice and Empowerment, Government was happened. They have to compute and pay. I believe it was there. I'll just check up and get there. I'll pay it out.
If it is by the whoever is either by the department or the district commissioner, for the district commissioner, Mr. Roy, you can perhaps take the instruction what SOP this Mr. The deputy SGI has placed before this court 159 that gazette. There is a a table, a schedule. Payments have been already specified. At least this amount he'll be entitled to. But madam, you had already appeared on the last occasion for response number 3. Who is 3? Who is 3?
Director of Welfare of Scheduled Caste.
So this will not be paid by the directorate, it will by the. How much amount? So what is your payment? What payment have you made? Payment for?
When the writ petition was filed, when I was not the legal aid counsel, someone else was handling. I presume it's 500 plus more crores it has been claimed as a way of compensation.
54 lakhs, my lord, it was paid first as first installment and thereafter.
34 lakhs.
For commercial pilot trading license, it was paid in 3 installments.
And then
The case is
11 lakhs in 2017.
1144,770 in 2 parts and 79,460 third part.
Affidavit, my lord, it starts from page 188, my lord.
And the order of the commission was never challenged by anyone.
So we'll take the instructions regarding the payment.
That's why the last order came.
He wants the compensation. From compensation part, my lord, deputy commissioner will.
Yes, you take the instructions, okay.
In terms.
Heard Sri S. Bonik, learned legal aid counsel for the petitioner. Also heard Sri R.K.D. Chaudhary, learned deputy HGI. Deputy HGI, Sri S.S. Roy, the learned state counsel, and Miss P. Chakraborty, learned counsel, standing counsel. Social justice. Social justice.
For the state is not being made a party.
Commissioner and Secretary, Social Justice Empowerment is respondent number 8, I presume. Implemented by the order dated 14/6/24.
Social Justice Department. Full stop para. This court, by the last order dated 3/2/2026, had directed the Learned Standing Council Social Justice Department to apprise the court with regard to the methods and procedure to work out the compensation as recommended by the National Commission for Settled Caste. Full stop. The Learned Counsel for the respondents have referred to a Gazette notification dated
14/4/2016.
14/4/2016 and enclosure what?
Section 3.
Annexure 3, which lays down the prescribed amount to be paid in different cases. Full stop.
31.
Be that as it may, both Ms. Chakraborty and Sri Roy, the Learned State Council representing the District Commissioner, pray for some more time to obtain concrete instructions in this regard. Full stop. Para. List. When? When, madam?
2 weeks, 2 weeks.
Where's the list on 1st of April? Not 3, Annexure 31.
Wait for me. Item 38. Please, this matter, let's my lord, file this writ petition, seeing the addition, my lord. To the final corporation to return back all of
Item number
38.
Yes, what is this?
Yes, my lord. Seeing the addition to the final corporation to release all documents were submitted.
The rejoinder has come.
My lord, last occasion, my lord, now we filed an affidavit in reply, my lord. In that there has been some inadvertent mistake, my lord. So far as one of the legal head is concerned, Manjusri.
Yes.
Manjusri, my lord, here we inadvertently we made a statement that she was expired. But she is not expired, my lord. But she given my an option certificate saying that.
No, but we had recorded the submission of madam that you had made a false statement on affidavit. And we have also gone to the extent that if you make false statement on affidavit knowing to be false, then you will be entitled to an appropriate proceeding.
Problem is that, my lord, that Ranjit Kumar,
He was, my lord, he was a former senior assistant director at the Institute of Chartered Accountant, Government of India. He, my lord, retired. Now he is working as, my lord, associate dean, faculty of business.
We are not concerned what post you are holding,
because
mister.
We cannot communicate with him properly, my lord.
Then
my lord,
we
whatever is
then
talking-
initiate a proceeding. He'll come running to the court. Let him face a proceeding. Making a false statement that somebody is dead in the family.
He alive, my lord. We apologize for that. That is
Your apology will not do.
inadvertent mistake on
Statement
our
has,
part, my lord.
it is not inadvertence. By inadvertence, you cannot make a live person dead.
No,
And that to a member of your family only for some property dispute.
No, my lord, that I'm coming to that, my lord. My lord, facts remains, my lord.
You have
Yes.
not explained.
My lord, facts remains, my lord. Yes, my brother availed loan 2,80,000.
No, we are not on that. We
my
are
lord-
on the aspect of making false statement on oath by knowing to be false. At times, we come across cases that incorrect statements are made, but by inadvertence. Here you have made a family member dead. Can you say that I was not aware that he or she was not dead?
But maximum time I stay, my lord. It is my problem. I apologize for that, my lord. For that, my lord, for makes a statement, it would not cause any damage to anyone, my lord.
That is besides the point.
My lord.
We will not go to the extent of whether it's causes damage or not.
Because, my lord, when my father failed to repay the payment,
Mister, I think it's a quit case. We draw up a proceeding. There is no explanation coming.
my I apologize for that. On his behalf, I apologize for.
Who is apologizing, mister? Are you seeking your apology?
No, my lord. On behalf of my client.
Where is the apology? Where is the affidavit coming? On your suit, will you make a false statement on oath and then you apologize? And you expect us to accept that kind of an apology? What kind of apology? What apology?
My lord, Deepak Samaj expired, leaving behind 4 sons and 2 daughters. 3 expired, 3 sons expired. Except me, then 1 daughter. Then we made a statement, my lord. It's mistake on our part.
Mistake on your whose part? Mistake on the drafting part or mistake on the instructions part? You make your family person dead because of a family property dispute. This is a 226 proceeding, sacrosanct in nature.
Yes, my lord.
You make false statement knowing to be false and you expect this court to proceed. We'll proceed against you, not against the respondent.
My lord, against the loan amount, we have realized 31 lakhs, only against 280 lakhs. At that moment, now, did you not charge?
We are not concerned with the property, how much is involved, who are you, what post you are holding. We are not even concerned or bothered even. That makes you even more responsible. If you are holding such a high post, you make false statements on affidavit.
If you allow me to withdraw my lord, then I will withdraw my lord if you allow.
How do you withdraw?
This affidavit, particular affidavit.
Can you withdraw an affidavit? Where is the provision of law to withdraw an affidavit? Show us. It cannot be so easy. You file something on affidavit, you fall in a different difficult position, you withdraw. That's not going to do. Yes, what is the appropriate provision, Mr. Goswami, for initiating proceeding under the new act? CRPC, we know. What is the new act? You come prepared, we'll initiate a proceeding. So, CRPC counsel. Was it 431? Yes, isn't it?
reconciliation. Two two nine. No. Two. Two of the BNS. BNS is this. Two 57. Giving false evidence. 190 on Bradwicks. DR. This 7. No, not this. In a court proceeding. We're not on this. There is a case. What was the name of the case? On some Ansari versus so and so. Everything has been explained. 341. What was it? We'll have some other day. We'll have it tomorrow. Tomorrow. Heard Sri F.K.R. Ahmed, learned counsel for the petitioner. Also heard Ms. T. Goswami, learned counsel for the AFC. Perused the last order dated 5/3/2026, in which this court had recorded that in the rejoinder affidavit filed, false statement has been made by the deponent knowing the same to be false, full stop. This court had accordingly made certain observation in respect, questioning the bona fide of the petitioner. What is the date of the rejoinder affidavit? Madam?
On 6/2/2026.
The rejoinder affidavit was directed to be brought on record, which has it been done? In spite of a clear direction to bring such rejoinder affidavit said to have been filed on 6/2026.
6/2/2026, comma, the same has not been tagged with the records, full stop. Para. List, matter accordingly stands adjourned to be listed on 16th of March 2026. On which date the rejoinder affidavit is to be tagged with the records, full stop. Registrar Judicial is also directed to make an inquiry as to why the rejoinder has not been tagged with the records in spite of a clear direction given on 5/3/2026.
Item 29.
May I please, your lordship, in this case, lordship, yesterday we have filed rejoinder affidavit to the affidavit opposition filed by the proportion department, and we have served copy to the proportion. And lordship, this affidavit is yet to be the part of the record, lordship.
Okay.
So lordship, may I please.
Okay, what is your name?
J.M. Gogoi.
Sri J.M. Gogoi, learned counsel for the petitioner, has submitted that a rejoinder affidavit has been filed yesterday, which has not been tagged with the records. Para. Matter accordingly stands adjourned to be listed on 18th of March 2026, along with the rejoinder affidavit.
Available.
Item 40. Well, in the
40.
case, Lordship directed for filing of the exceptional position, but it seems that.
File,
No.
not file.
Lordship, I have received the instruction. I pray for 3 weeks back.
Receive the instructions.
Yes.
And Mr. Kyle here for whom? Who is 7? Okay, we grant some time. Okay, heard. Sri A. Saraf, learned senior counsel, assisted by Sri Datta. N.M. Datta. N.N. Datta. Full stop. Sri B. Chaudhary, learned standing counsel, Finance Taxation Department, has submitted that though affidavit was supposed to be filed, comma, the written instructions have been received. On the basis of the written instructions, on the basis of the written instructions, comma, he has renewed his prayer for grant of some more time to file the same. Full stop. Para. Accordingly, matter is adjourned by further 3 weeks to enable filing of such affidavit. Para. List on for 2nd of April 2026. Interim order passed earlier to continue till the next date of listing. But we had the understanding that by this time even the rejoinder would be filed. Why are you late, Mr. Chaudhary? We given 2 weeks extra to rejoin your the affidavit. Okay, next.
Can it be on 6th?
Okay, on 6th. 6th November. 2nd November, 6th. 6/4. 6/4, Mr. Oh. Yes, next.
41. Well, in this case, the matter of issuing summons, the lordship directed for filing an additional affidavit. That
Yes.
was filed, bringing on report the necessary facts.
Not. I'm praying for 2 weeks' time to respond to that.
Yes, we remember this case. One director had gone there for 6 days. Then another director was, and that was without any jurisdiction. Yes, what do you say?
We will file our detailed affidavit. Lord. 2 weeks' time maybe.
Okay. Heard. Dr. A. Saraf, learned senior counsel, assisted by Sri N.N. Datta. Full stop. In this case, notice was issued on 23/2/2026 and pursuant to the observations of slash directions made, comma. The petitioner has also filed an additional affidavit which has been brought on records, full stop, para. Sri S. Chetia, learned standing counsel, CGST
Lordship.
submits that he would be filing a detailed affidavit in opposition. Full stop. For which he prays for 3 weeks' time. Is it 3 weeks? Para? Matter accordingly stands adjourned to be listed on 1st of April. Is it okay?
Second point.
Let it be on 6th.
6th of April. Para, interim order passed later to continue till the next day of listing. Okay.
In fact, they should start the proceeding for adjudication. They are not doing, only fighting here.
Yes.
The interim order.
No, I have got an interim order, I'm not saying.
42.
My pleasure. Accordance to the last order which was passed by this court, my lord, they were to seek instructions on the appointment of special public prosecutor at the FU, my lord. Was a
Yes, Mr. Roy.
statutory requirement.
Pay for some more cycles.
My lord, actually,
How much time?
2 weeks, Lordship.
To get the instruction, Mr. Chaudhary, you are for whom?
I have for everyone. And we used in the main proceeding.
Oh, yes, you had appeared, who had appeared? Yes, so what business do you have here?
Otherwise, I am also interested in an appointment of a special PP because there are certain facts which might be relevant. And there is
No,
a
see, Mr. Chaudhary,
there is a
even if
connected-
we allow the petition whole hog, we are not going to make one single observation on the merits of the
No,
case.
I'm not done.
So in that view, if you come and get yourself implicated to oppose,
No,
that might give,
I would rather be.
then you withdraw this.
I would rather be supporting. There is one aspect, if your lordship will kindly.
No, we know about the respect. Second part, we want the court to be functional. That is our endeavor.
We are on that part. What was happening is, just to indicate why I am seeking it.
Yes.
What was happening is, the proceeding proceeded in absence of a special PP. We brought it to the notice of this honorable court and this honorable court passed an order. On the very next day, the deputy commissioner intervenes. There is something which is not right. The deputy commissioner intervenes and he assumes the power of the state conferred by the statute. He appoints on the very next day an advocate and they seek to proceed. That is where I filed a writ petition and that has been stayed. So these are certain factors.
No,
Otherwise, I would not be opposing.
Irrespective of what has happened, now the present appointment has to be done strictly in accordance with law. For that, we require his instructions. What steps he is taking? Okay.
And perhaps your lordship may like to tag this matter with the other one, which I have filed and it is pending. That
This
may
is
have
with a limited prayer. Your grievance we do not know. In that whether Mr. Mir is a party, that also we do not know.
we are not, my lord.
No.
And then we'll adjudicate a matter independently.
That
My lord,
that
absolutely, my
might
lord.
have a consequence. That is what I wanted to point out. That has been annexed in the writ petition. If your lordship will kindly come to
What is your prayer in your petition?
there, my lord, an appointment was made by the deputy commissioner.
No, that will be taken care of if
Whether-
the new appointment is made.
No, if that appointment remains, perhaps it may not be proper to proceed with this.
No, there is a stay order.
There's just a stay.
There is a stay order.
So perhaps your lordship might like to have both the matters together.
There is a stay order.
And I'm agreeable to a disposal as soon as they have the instructions. I won't
Now,
perhaps.
Mr. Roy, if Mr. Chaudhary has a case so far as the appointment of another person is concerned made by the deputy commissioner, you are the best judge. You make the appointment in accordance with law, strictly in accordance with law, and we want the proceeding to go on, continue and be completed. These are matters under a special statute. This should not remain like this. Okay. Okay. We'll have the IA still alive. We're not dismissing it. And come back after 2 weeks with concrete instructions. Okay. Heard 3 AA Mir Learned Counsel for the petitioner. Also heard 3 SS Roy Learned State Counsel. Full stop. In this writ petition, IA 739/2026 has been filed for implement, and the applicant is represented by Sri I. Chaudhary, London Senior Counsel, assisted by Mr. Ahmed, A. Ahmed, full stop. While the consideration of the IA is deferred, comma, Sri Roy, the London State Council, has prayed for some more time to obtain instructions in terms of the order dated 23/2/2026, full stop, para, list on 7th of, so not 7th, why is 7? Today is 11, 2 weeks we have said, on 27th of March. Okay, 27th we'll try to pass final orders, 27th of March.
Consider whether tagging it will be the one filed by me. Because almost an identical issue. There I am challenging the appointment.
That can be allowed. That will
That
be-
is actually a bench three matter, and what he has sought for in that is for a stay of the appointment of that particular individual, my lord. That has been stayed. This we are just for an appointment of a special PP, my lord.
No, if that matter remains,
my lord,
that needs to be
In case it
disposed of.
goes against me, then it might have a consequence on this.
No, even if you allow, he'll not have any.
Exactly, my lord.
That is
He'll
why-
not have any grievance. We can allow that.
Yes.
You take first let him have the instructions, then
My
we
lord.
can have that matter tagged, then.
My lord.
Okay.
Yes.
Obliged, my lord.
Okay, 3:30 we'll have to rise. There is a meeting, so order matters, only urgent matters will take up.
64. Only one bed.
Admission আছে নেকি?
What's this matter relating to holding of election of trade union on GC?
Holding of?
Election of trade union in GC.
Okay, yes.
What's if we file an IA also?
Are you for?
For vacating interim orders. dated
Lordship,
20
kindly pass it on, put a time being, sir. My senior is
Who is your senior?
PJ Swigya, sir.
Okay, Mr. Dr. Saraf, you are for whom?
Well, I think 15 time.
15?
50.
Oh, not this matter.
No.
Oh, okay, just wait for a while.
And for respondent number 11, as per Lordship's last order dated 15/12/2025 and 22/1/2026, the court had directed all the respondents to serve us the copy affidavit they have filed. As such, respondent 7 to 9 has not served us a copy, and the copy of the IA also we have not received.
Lordship, here, Lordship, please to see how the proceeding gets delayed. Initially, respondent number 1 didn't appear. After appearing, Lordship.
Why didn't you serve copies?
We sub copy all.
No, they have not received copies.
I am appearing for respondent number 10. We have served and we have received.
We have not received copy of 7 to 9 and
I
also
am,
the IA.
I am for respondent number 10. Lordship, please to see the election is for 2 years. Since 2019, last election was held. Now 11 is Lordship is trade union. He is holding the post.
But Lordship will have to have the copy to record. And also they have just.
Who's filed the IA?
We file like.
Give him a copy. What is the problem?
Lordship, there is no problem. Lordship, please to see.
No, give him the copy. We'll have it on Tuesday. We'll have these matters on Tuesday. Some copies are yet to be exchanged.
Tuesday. They have just handed over the copy.
Okay. Let the exchange be complete. Mr. You'd ask for?
And for 2, 3, 4, 5, and 6, we have already started the copy.
Yes,
But one thing that Lordship, I would like to point out. This election is regarding the shifting of constituency. As per the policy of ONGC, the entire India, the constituency has been established. Here they want.
Okay, Tuesday we'll tell here.
Can be
Tuesday.
Can be on 24th. That is also Tuesday, my lord.
Why 17th we'll have it. We'll finish. Aren't you there at Gauhati?
there, but
We will accommodate you. Don't worry. 17th.
Lodge.
Complete it.
Lodge.
Okay. Heard the learned counsel appearing for the parties. Full stop. Though there was an issue with regard to exchange with regard to furnishing of copies of the pleadings and IA, comma, the same has been completed today in the court itself. Full stop. Para. List for admission hearing on Tuesday. Tuesday we'll try to complete this, finish this matter.
Matter relates to remission of the life convict. He is about 26 years in jail. But
Some instruction launch.
You have instructions. What is the instruction? Has it been considered by the review board?
no, Lord, review board rejected it on the ground. Lordship will get it at page 52.
Yes.
That on the ground escaped from jail for 5 years while on leave. But my lord, the custodian of the prisoner, the superintendent of district jail, his report is that, my lord, at page 51, on all occasions when I was on leave, I surrendered on due date and time. That is the leave account says, my lord. But how the Inspector General of Prison rejected it on the ground that I escaped.
This factor appears to be perverse, Mr. Goswami.
And all the authorities have recommended for my remission.
See, the reason which you have prescribed, which you have assigned for rejection is a good reason, that he had escaped while he was in leave. But if there is a report to the contrary, that whenever he is on leave, he had surrendered back on the same date, then that finding that he had escaped appears to be a perverse finding.
His period of escape was 17/11/2010 to 18/2016. That period is not in this.
But my lord, page 51 says the superintendent of jail, he is the custodian of prisoner. All along he said that he returned.
51 is what? A report?
Yes, my lord, the leave account. Leave account and my lord.
But why will the review committee come to an erroneous conclusion? There has to be something.
Because that period is not in the process.
Leave account.
Yes.
But my lord, that is not.
Which page are you?
Page 51, my lord.
You take instructions on page 51, how this was.
And it is stated that I availed the leave on 4 occasions. That I don't know. That 4 occasion has been recorded here at page 51. And
Let us see the findings of the review board.
Page 52, my lord. Page 52. Serial number 2. The reason escaped from jail for 5 years while on leave. That is the ground for rejection.
Now, this is a good reason, Mr. Haloy. But your leave is only confined to 4 occasions or what?
Yes, my lord. 4 occasions. This is
This period is of which period, Mr. Goswami?
17/11/2010 to 18/3/2016. That is not in this.
From where do you get this instructions to put this on affidavit? That the report of the superintendent of jail may not be a conclusive or a complete report.
Yes.
It only encompasses 4 annual leave in the year 6, 7, 8, and 10.
He escaped laws.
Okay, you file an affidavit. Okay. Your legal aid counsel.
legal aid.
Third, 3 KM Haloy Learned Legal Aid Counsel for the petitioner who is aggrieved by an order dated 24/10/2024.
2024, my lord.
2024, whereby the prayer for remission against a life sentence
My lord.
has been rejected. Full stop. It is contended that while the impugned order reflects that the petitioner had escaped while on leave, the petitioner has relied upon a report by the Superintendent of District Jail Golaghat, wherein it has been observed that on 4 occasions when the petitioner was on leave, he had surrendered on the due date in time. Post of Sri Goswami, the Learned State Council has, however, responded based on written instructions that the report of the superintendent is only confined to the period 2010, and the escape for 5 years was from 2011 to 2016. Let this aspect be put on an affidavit. Which affidavit? Footstep. How much time? Sri Goswami, the Learned State Council, accordingly is granted 3 weeks' time to file such affidavit. List on 3 weeks. 1, 2, 3. List on 7th of April.
7th of March.
Orders.
But I have one correction of order, madam.
We'll do that. Mr. Dr. Saraf, which is your matter?
Item 50, item 50, we file an IA for modification of the order passed by class, whereby they were directed to deposit some amount of tax. I guess that Lordship, I want to place only one paragraph. Because Lordship, there was a difference of 22,000 cases. Second read.
And if it's urgent, we can have it tomorrow.
Well,
Tomorrow we'll have. Okay. On a joint request made by the Learned Council for the parties, list for consideration tomorrow.
Right.
Tomorrow is Thursday, we'll have time also.
Smile.
It will by sleep Kurdiva. Okay, Mr. Sixth case, which one? Some correction?
Item 48.
What key correction?
Your Lordship would be pleased to take this IA, my lord.
Yes.
IA. And in my petition, my lord, your Lordship will turn to page 6.
Page 6.
Page 6, my lord. Para 4. It is necessary to make necessary correction in the order dated 8/11/2024 in para 3. Your para 3, your Lordship will get at page 10. Page 10, madam. Para 3, your Lordship would be pleased to see there is a chart, my lord.
Yes.
Here, my lord, Wazidul Islam, serial number 2. Wazidul Islam is written as daughter.
Yes.
It should be corrected as son, madam. Only that correction.
Where is the petition?
My lord.
Petition was disposed of.
My lord, disposed of. After obtaining certified copy, my lord, we detect this mistake.
But you have written as daughter in paragraph.
My lord, that is
2.
why, my lord. That is why, my lord, I filed amendment petition.
Was
That
it
amendment was allowed by your Lordship.
When was it allowed?
Yes, it was allowed, my lord, your Lordship.
Let this be listed before the appropriate court. I think that will be the best.
My lord.
I think that court. Okay. Heard Sri M.E. Sikh Learned Counsel for the applicant, who by means of this application has prayed for correction in the order dated
8/11.
8/11.
24.
Page 10, my lord.
8/11/2024 passed in the connected WPC 5699 of 2024. It is contended that while describing that that in paragraph 2 of the said judgment, the they said order, comma, in paragraph 2, comma, inverted comma, Wazidul Islam has been written as daughter, which should have been son, full stop. This court has, however, looked into the records of WPC 5699 of 2024, wherein the petitioners on their own, on his own has made such a description, full stop. The Learned Council has, however, informed that subsequently an amendment application was filed to this effect, full stop, which was allowed.
Yes, allowed.
Which was allowed. Full stop, para. In the fitness of things, comma, let this matter be listed before the appropriate court within bracket Honorable Justice M. Chaudhary, which had passed the order. Full stop. Okay.
My lord, only thing is this one, possibly it is written as para 2, it will be para 3.
Para 2 only have said.
My lord, para 3.
Para
Page
3.
10, page 10,
Para 3. Para 3.
Obliged, lord.
Serial number 2.
Serial number 2.
Okay, rest will give dates.
My lord.
Is there any matter where interim order is still today?
Lordship, with regards to the last item number 52, there was an observation in the last order that no major financial decision will be taken by the council. Lordship, that observation may be continued, your lordship.
Item number
52, your lordship.
Is it limited by time?
Lordship, the
52, huh? Positive. Interim order passed earlier. Stands extended till the next, huh? Positive or like that. Yes, anything?
Lordship, item number 49. The Lordship may give some other next to.
He'll give, court master will give it.
Your Lordship, the matter may be listed on admission. Your Lordship, because on the basis of he was involved in child marriage, on the basis of sorry.
They'll give a date, we'll consider.
Okay.
Okay. Any matter where interim order is still today?